Honorable Senators, may I inquire, each senator should have 5 sets of amendments. We have the amendments. Senator Mark, Senator Richards, Senator Thompson-Nye, Senator Vera, and the Attorney General. May I inquire if everyone has those sets of amendments?
Thank you.
So apparently, Senator Mark is in the unique position of circulating 2 sets of amendments. So now we should have 2 on behalf of Senator Mark, Senator Richards, Senator Vera, Senator Thompson-Nye, and the Attorney General. It's being circulated as we speak.
You got it, that's not? Yeah,
No.
This is yours.
So, Honorable Senators, as we begin the deliberations, there are quite a number of amendments being proposed. I therefore ask for everyone's undivided attention as we go through the bill, so that there will be no request to go back to anything. All right?
Clauses 1 and 2.
The question is that clauses 1 and 2 stand part of the bill. The question is that clauses 1 and 2 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 and 2 now stand part of the bill.
Clause 3.
The question is that clause 3 stand part of the bill. Yeah.
I know, but for the first, I think this is the first one. Definition of domestic, no, this one had the definition of child.
So the shortest amendment circulated with respect to clause 3 is that on behalf of Senator Mark. Senator Mark, therefore, can we hear
What I'm seeing is that I think Senator Anthony Vieira and I seem to have the same amendments, if I'm not mistaken. No. Yes, I think, no, I think he has. I did the front.
okay, Senator Mark, you need to speak so that we can hear.
Yeah. I think that in clause 3, what I am trying to accomplish in clause 3, I think Senator Vieira is going a little deeper.
So will you withdraw yours then?
Yeah, I will withdraw mine in favor.
So Senator Mark,
My clause 3.
so
Then
Senator,
look at yours. I realize you're going deeper. So I will
so
withdraw
Senator
mine.
Mark, you've withdrawn yours?
Yes, yes.
Thank you very much. We now move on then to Senator Richards.
Thank you, Madam Chair. The submission I have is on the suggestion of the Law Association, the Alliance, Roberta Clark, etc., and it suggests that in paragraph I, inserting the words, quote, a domestic relationship with the respondent, the words, end quote, sorry, the words, quote, or a person who is a member of the same household as the respondent. It seeks to widen the eligibility criteria a bit for that clause.
So for those other senators, Senator Richards is speaking about a proposed amendment at page 8 of the bill. Correct?
Yes, Madam Chair. No, page 8.
Attorney General.
Trying to locate the amendment, quite frankly. So it's in paragraph I,
Yes,
which is on page 8,
correct.
and it's in the definition of domestic violence. So he's saying after the words a domestic relationship with the respondent, by deleting all the words after the words committed by and substituting the words a respondent against a person who is in a domestic relationship with the respondent, and insert the words or a person who is a member of the same household as the respondent. Could the Honourable Senator just explain the rationale for this amendment?
Thank you. Through you, Madam Chair. It was upon the suggestion of the Law Association and the group, the Alliance, and the intention was to widen the eligibility criteria because in some instances, the individual who may find himself, even though the original draft is quite extensive, outside of the ability to proffer the complaint against the respondent.
Madam Chair, thank you. Thank you, Honourable Senator. Through you, Madam Chair. My difficulty, why I asked the question, is that this says a member who is of the same household. Member of the same household is defined as someone who is related to the applicant or respondent by consanguinity, affinity, or adoption. B, is or has been the subject of an order under the Family Law and Guardianship of Minors Domicile Maintenance Act. Is a fit person, subject of a fit person order or foster care order under the Children's Authority Act, or has been treated like a child of the family. So, respectfully, that is captured in the definition of domestic violence, because domestic violence goes to domestic relationship. Domestic relationship captures dating relationships, visiting relationships, and members of the same household. So the way I read it was that it is caught already. So I didn't understand the amendment as broadening the definition in any way.
Would those, through you, Madam Chair, would those also include, I know you mentioned it in your wrapping up, Attorney General, persons who may be in the employ, or would that come under the proposed legislation as you mentioned in your wrapping up?
So the persons in employ was a category that we had not proposed to include in the context of domestic violence per se, because we felt that employment was something that was better captured under a different area of law. Economic abuse is caught under the Trafficking in Persons Act, for instance, is a very specific category. So we didn't want to conflate the two issues of what is pure domestic violence with what other laws could speak to. For instance, sexual harassment, or economic exploitation in the context of trafficking in persons, which treats with that specifically.
Well, I will withdraw, but I mean, it was with that intent partly, because presently those persons are not protected by law because of the absence of that kind of legislation. But I will withdraw.
They are protected by law. They're protected by a different law. They're not protected by the Domestic Violence Act, threat, harassment, etc., in the context of domestic violence. In all of the literature that I have come across and the laws that we have looked at, the concept of domestic violence, to be true to purpose, at least from the policy that we drive these reforms, is to really associate it with the context of family dependency and relationship. Now, I do, of course, respectfully understand that you're dealing with, for instance, a domestic live-in.
Live-in, exactly.
Right, who may be under that sort of umbrella as well. I do understand that. But because the parameters of that are caught with under economic exploitation, and in fact the Minister of Labour has been pushing hard at several years now to try and get further reforms to the ILO conventions that treat with those aspects. Respectfully, we have not gone so far as to include that aspect of economic exploitation, because that is the major category for me is economic exploitation, which has a subset characteristic of those features. So you're sort of into two areas right now. My fear is in causing these amendments now, and in looking at how the courts are going to interpret this, we didn't necessarily want to conflate the two issues into one point, especially because we've taken 21 years to come forward with amendments now.
No, understood. With that said, Madam Chair, I'll withdraw.
You withdraw it?
Yes, thank you.
So we now move on to the amendment as circulated by Senator Vera. Clause 3.
Thank you, Madam Chairman. Attorney General, through you, Madam Chairman, my amendment does not really add any words to the definition of member of household. It simply calls for a reconfiguration. The way it is cast at present, you have two things that are required. You have to have your ordinarily or periodically residing in the house, and then you also have the relationship by blood, marriage, or adoption. With respect, that tends to be unnecessarily restrictive. So my recommendation is member of the same household in relation to an applicant or respondent means a person who, A, ordinarily or periodically resides in the same dwelling house as the applicant or respondent, B, ordinarily or periodically is related to the applicant or respondent by consanguinity, affinity, or adoption, and then C and D will continue as you have it. That would broaden the categories without doing harm to the intent.
May I, Madam Chair?
Yes.
Thank you, Senator Vero. So we've had 2.5 years of discussion on this particular issue. And in looking at the realities of the domestic violence law, we were really grappling with what Trinidad and Tobago looks like. And I'm going to use the concept of what Jamaicans call yardies. Or if you come to parts of my own constituency, for instance, where there's thick and dense household interaction, but they're not households, but they can be households, and there's constant conflict and dispute between people, we were going to cross into very dangerous territory. If you come to some of the very, very, very depressed communities that I represent, I fear that this will be Pandora's box in some senses, because the domestic violence prescriptions offered here are emergency orders, offense if it is not complied with, ex parte upon certain satisfactions, etc. And what I have concern with at this point, and I mean it from a policy point of view, where do we draw the line on somebody who is attempting to include him or herself in as a member of a household when they're in fact not a member of the household? So the conjunction of consanguinity and household or affinity in the chapeau as we had it was purposeful. It was intended from our perspective to narrow the gap somewhat, because we intended that people who sought to rely on harassment or other areas of criminal law really ought to be captured in that secondary category. If you get to later on in the act itself, the Criminal Law Act applies, and you have to charge someone when a policeman enters without warrant or policeman meets a situation of violence, etc. The Domestic Violence Act says that you must charge that person under the respective laws that you come on to. So from a policy perspective right now, having wrestled with this issue for nearly 2.5 years, the debate that we had in the several committees that we sat on was how far to open that particular door in the context of Trinidad and Tobago society. And that's the position. Now, I'd like to say the recommendation that I got from the coalition together with the Law Association and the Equal Opportunities Commission, that was squarely rooted in the LGBT issue. And the recommendation that they made for this was to capture that. And my submission to the several persons, because we sat for 2 Zoom meetings in a row for several hours, my submission into that was that because as Attorney General I have taken the Jason Jones case forward to the appellate court, ultimately to the Privy Council, so that the law can be settled once and for all, and because that Jason Jones case affects 23 other laws in Trinidad in the same issue, that I was very cautious about the implied repeal aspect to the law. And that is the reason that I had volunteered to the several members who were advancing that issue. And when we come to Senator Thompson IE's issue, we'll see it again. But I told them that I had to be extremely careful because I wanted the direction of the Privy Council on that issue to assist me with the prospect of how to clarify the law.
I will be short.
I think Senator Choate wants to say something first. Senator Choate?
Thank you, Madam Chairman. And thank you, Senator Vera, for allowing me to just put in my 2 cents before. Honorable Attorney General, I did not meet with the Law Association, but I see the good sense in the proposed amendment from Senator Vera for 2 reasons. One came from the very thing you said, where you have communities where people live in yards, and what is a household can become quite a fluid thing. To me, the recasting of the definition in this case doesn't open the Pandora's box, because you have the court as the sieve. What it does, it embraces a wider group of people who may be in need of protection, especially within tight-knit communities like that, especially the vulnerable, who may be in need of such protection. Secondly, I will use a real-life example to say why I support the amendment. And that is a phenomenon we have of elderly persons, many of whom live alone, who have persons move into their homes and live there full-time or part-time. They're not related to them or anything like that. But essentially, they reside in the same dwelling house. There was one incident which has been mentioned in the Senate by different senators on several occasions about a certain lady in Curep, and it has been reported in the news media and that kind of thing. But the thing is, she is not the only person circumstanced like that, but she may be in need of protection. So if we are aware of live cases or possible cases that we can think about, then we ought to use the opportunity to make the legislation afford as much protection as it can. So that, respectfully, is my recommendation.
Senator Vera.
Attorney General, let's look at the LGBT issue for a minute. This law is about protecting persons against domestic violence. As far as I'm aware, everybody is equal under God's sky. Lady Justice is blindfolded, so she does not discriminate. I am against anything that would unduly discriminate against people who are vulnerable and deserving of protection, whether they're too tall, they're too fat, they're too thin, they have blue eyes, is of no moment to me. This is a necessary and important amendment.
Attorney General.
So I share Senator Vera's passion. I recall this very argument when we were dealing with the Children's Act back in 2012, when the independent bench did not support the amendments that came into law. It was the opposition and government that supported that on the same issue, joined in with the issue of child marriage. I have made very public statements that the law will ultimately be settled, and I want it urgently settled by the Privy Council. And I have said that I'm extremely careful about the issue of implied repeal. Because I have a first instance decision in Jason Jones, which I have publicly stated I want settled by the Privy Council, and I have a fair indication of where the Privy Council will go on that idea. Because it saved law and it affects 23 other laws, I agree with you, Senator Vera. But as Attorney General of the Republic of Trinidad and Tobago, knowing that I have the case on appeal, and knowing that we will go to the Privy Council, and knowing that I have 23 other laws to manage at the same time, when I make this amendment now, if I'm invited to make it as you're recommending, and correctly so, I compliment you for your approach on it. I share the approach. My problem is that I will cascade into litigation that I cannot manage easily. And therefore, in the same way that I made the exhortation to the members of the Law Association and others, and they agreed to actually step away from it until they wrote a letter subsequently, and they asked for it to just come to the floor of the Senate as it has. What they told me they would do is that they would write, and that they would write and share with the independents and opposition so that the issue can be articulated on the floor. And I have no objection to that approach by them. But I repeat the same rationale that I did to them. I have to manage the issue in a holistic way. And in doing that, I must be mindful of what I'm going to get from the Privy Council, which will cascade into 23 other laws. It was for that reason that we wrote the Trinidad and Tobago report, the MESEC report to the United Nations on human rights. And Senator Thompson-Ayi, in fact, read it out in terms of her contributions today. So my difficulty in accepting the amendment at present is that I have other laws that I've got to balance in accordance with the Jones decision, which I expect to be coming sometime during the course of next year. If I look to the point raised, the example that Senator Choate raised of elder abuse, we've captured that in the law as it is, because we deal with persons who are dependent upon someone else looking after them, adult members of the household. That's caught in sections 4, 6, 10, 19, etc. So that example has been amplified into the law right now. The only thing that is left outstanding here right now is whether one separates, in the manner that you have suggested, the chapeau, because that's what you're ultimately suggesting, delink the consanguinity or affinity from being a member of the household. We've done that for the elderly. We've done that in the dating relationship. The only one that we've not done that for is the visiting relationship. And the visiting relationship has not been amended because I'm awaiting the Jones decision. Because the visiting relationship is where you define husband and wife. And that's where that mischief is. So I need the Jones decision. This is one of the 23 laws I'm talking about.
And then Senator Chute.
Madam Chair, may I suggest that this is a very important matter that we are debating at the committee stage. Could I respectfully suggest, through you to the Attorney General, that we defer this matter for later on in the proceedings rather than attempt to take a decision on it now?
The issue with that is that we still have to deal with Senator Thompson-I's proposed amendments to Clause 3, and it's going to get very messy if we keep dealing with one set of proposed amendments and then having to come back. So we're trying to deal with this as cleanly as we can at this stage.
So Senator Hayes is in Clause 3 as well?
Yes.
Yes.
Okay.
Senator,
Well, when that comes, we can always come back to this.
Senator Chute.
Thank you. Response doesn't answer the concerns articulated either by Senator Vera or by me. When I spoke about the situation with the elderly woman, I'm not talking about someone who is in, who has a caretaker living at home and upon whom the elderly person is dependent. I'm talking about the phenomenon which has arisen in our society of strangers purportedly coming into the household. It may be as a tenant, it may be as a licensee, it may be as a visitor, who have no relationship at all with the elderly person, but knows that that elderly person is living there and living there alone. So they move into the home with a view of taking the home over together with the contents of the home. And that elderly person doesn't fall into, well, it could be that I have missed it, but doesn't fall into any of the categories within the legislation. So this is why I'm thinking that if it is reworded, as Senator Vera suggests, that such a person will now be protected. The other thing, which you did not address at all, was the very thing which affects communities within your constituency and many communities in urban areas where you have yards. And because there are young people there, remember domestic violence hits the demographic of 15 to 25 the hardest. You have young people in there who are subject to violence from gang leaders who may or may not be related to them or who may or may not be in their households. This gives them a measure of protection. A court order is not like going to the police and trying to get a conviction for such a person. So it allows them to benefit from some kind of protection or try to benefit from some kind of protection. We have seen videos, Honorable Attorney General, of a young woman being beaten by alleged gang leaders circulating, on social media while mothers look on because they can't do anything. So these people may now be protected or they may die. So let us, while I take a point with respect to Jason Jones, I disagree with it because if we are talking about human rights, let's talk about human rights. But I am also saying let us not throw out the baby with the bathwater.
Attorney General.
Sure. Well, we're talking about members of the same household. So, first of all, I wish to apologize if I didn't answer the second part of your question. I answered it, the first part, in the context of addressing the issue of the elder abuse. I catch the different example you've given me, and in respect of that, I'd just like to remind that we passed the home invasion and occupation legislation in this Parliament to treat with that, specifically for those circumstances, because we recognized as a government that that was a serious issue, and we treated with that in the amendments to the Trespass Act in this Parliament already, where we took trespass in the non-traditional trespass sense. It wasn't just a regular trespass. It was where somebody actually came and occupied. So we've dealt with that one already in terms of a different law that we've passed in the Senate. With respect to the other persons who may be beneficiaries, and I think that's a very good example you gave, the gang activity and the girl being beaten, etc. Senator Vera's recommendation, which comes to us, is that we're looking at the definition of member of the same household. And in relation to that, a person who is ordinarily or periodically resident in the same dwelling house as the applicant or respondent. The debate that we had for the several years that we were looking at this was the argument coming against the cleaving of the consanguinity or affinity away from that, because it did not give us the comfort that it wouldn't be too wide a provision at present. Now, I accept that one may wish to have an easier approach to protection, but in the domestic violence situation, if we look to where we look on the categories of Section 4 and Section 6 and then Section 10 and then 19, we're seeing that the application for protection order, forgive me, clauses, right, that clause the amendments to these sections, right? So Section 4 of the Parent Act, an application for protection order may be made by a person in a domestic relationship. And when we get to domestic relationship, that's where the definition begins to bite. And the domestic relationship is defined, as we now propose in this bill in Clause 3, to mean relationship, and we've defined it here, in relation to the respondent, spouse, former spouse, cohabitant, former cohabitant, child, dependent, relative, person agreed to be married, person in a visiting relationship, person in a dating relationship. We've introduced dating relationship to mean where the parties don't live together in the same household but may be engaged in romantic, intimate, or sexual relations. Visiting relationship was a previous amendment. It stands unamended as a non-cohabitational relationship, which is otherwise similar in relationship between husband and wife. And that was the one that I told you I was waiting on judicial pronouncement on to assist me with. The difficulty that I have in accepting the recommendation coming right now is that the caution, and CPC leaned over to me again when the suggestion was made to say that the position from a policy perspective and the umpteen discussions we've had is that that door will be opened too widely. When I looked at the other jurisdictions, I'm not seeing that relationship just yet unless we treat with the simple Jones decision position, because that's in many senses what we're trying to achieve and which we want to achieve. What I'm saying is that I'm temporarily hamstrung by awaiting the decision of the court on the issues, mainly because of the caution that I'm exercising in the saved law principle. And as you know, that is now in two different directions. There's the CCJ saved law principle, which has happened in the sedition case, versus the Privy Council decision. So it isn't that I don't want to treat with the issue, it's that there are quite a few moving parts around that issue that need to be settled. So from the definition of members of the same household perspective and the risk to child, adult, relative, person in, trespass has taken care of the persons who come and occupy those positions. When I dust all of those things away, the only thing left right now is to treat with the equality argument, as Senator Vera very passionately put it forward. And what I'm saying is, it isn't that I'm afraid to deal with the issue, it's that I want the issue to be settled because there are other moving parts on the issue. And what I'm suggesting by the settling is the Privy Council's decision on the matter.
Dr. Thompson,
Yes. Through you, Madam Chair, I'd like to ask the Attorney General, what was his thinking behind the amendment to the Sexual Offences Act. Because I am at a loss, because you were very clear in what you said to the United Nations Human Rights Council. So I'm really having a difficulty in tying this up with what you're saying now, because there was no doubt in your mind that this fitted squarely within the four corners of our Constitution, and you were talking about a gender-neutral position, and you were very strong in your view that you needed to provide protection for victims of violence in same-sex relationships. These are your words, and that's the same thing that we're doing here.
So, Madam Chair, most respectfully, this is a much larger discussion about same-sex relationships. I've been on record, I've answered in my tenure as Attorney General very carefully and clearly the government's position on this. We are awaiting the outcome of the Privy Council's decision in the Jason Jones matter. We are doing that for two reasons. One, the SAVE law issue, because all SAVE laws fall into that. And that is no small issue, and I'm sure every lawyer in this room will understand what I mean. But the second issue is that there are 23 other laws that I have to factor in this equation.
Attorney General, the courts do not make the law. The courts interpret the law. We make the law.
It's
if
true.
we say this is what we want, it's our law.
And in answer to that, Madam Chair, when I make a law here, the issue of implied repeal becomes very relevant. So if I touch a law today on an issue in one piece of law, the learning in law by way of interpretation is that there is an argument of implied repeal. And I am intimately aware of that. That's why I took senior counsel's opinion on the matter and why we said that we wanted the court to interpret the principle of law for us in clear terms.
Senators, I think that there has been enough discussion on this particular proposed amendment. So the question is that Clause 3 be amended as circulated by Senator Vera. Those in favor say aye. Those against say no. The amendment has therefore not been accepted. I beg your pardon? Oh. So as you know, we allow for 3 minutes for all senators to return to the chamber. Senator Vera, as the members are coming in, did you talk to B of your proposed amendment? Because I've just put a vote on clause 3, your proposed clause 3, but I'm seeing there's a B.
Want me to speak to B?
Let me just, yes, you can go ahead. We will suspend the division until we just treat with it.
Yes. So, sexual abuse includes sexual conduct of any kind that is coerced by force or threat of force and the commission of or an attempt to commit any of the offenses listed. But I am aware of situations where people have had communicable diseases and they inflicted it on a spouse or a loved one because they never told the person that they had that disease and give them the option or taking a precautionary measure. And I certainly think that the definition of sexual abuse should be expanded to deal with that situation. And that is the rationale of my proposed definition.
Vera, if I may, so we are treating with this at page 12 of the bill. Is that correct? Page 12 at O.
So the B, which is the definition of sexual abuse,
Yes.
would be, where is it? Is it page 12?
Page 12.
Right, yes.
At sub O.
Well, I didn't, yeah. Yes. It would be at B. Would it be at B?
But could, But could we ask Senator Vera, what are the words that you want? Because you've just simply said it, well, you haven't simply, you've said it should be expanded to include. But when you are proposing an amendment, it has to be specific to the bill. Yes?
Indeed, Chair, and I confess that I did not have a chance to actually frame the words. I just drew the attention to the desired outcome, but I will work on the words for you.
Well, you'll need to work on the words now, because we've just called in the entire chamber to deal with a vote on clause 3, but we haven't dealt with the latter part of your amendment. So can we try and treat with it now?
And perhaps maybe
So you're withdrawing the latter part, B.
the latter part only.
Is it the way? Members, we are treating with the proposed amendment circulated by Senator Vera. Senator Vera has indicated that the second part of his amendment at B has been withdrawn. So the question is that clause 3 be amended at A as circulated by Senator Vera. Those in favor say aye. Those against say no. I think Senator Vera has called a division.
Mr. Khan?
No.
Mrs. Gopi Schoon? No. Mrs. Batiste Primus?
No.
Mr. Rambarat?
No.
Mr. Sinanan?
No.
Mr. Moses? Mr. Hussain?
No.
Ms. West?
No.
Ms. Cox?
No.
Mr. De Freitas?
No.
Mr. Singh?
No.
Mr. Cummings? Dr. Henry?
No.
Mr. Dookie?
No.
Mr. Williams?
No.
Mr. Mark?
Abstain.
Ms. Haynes?
Abstain.
Ms. Amin?
Abstain.
Mr. Sobers?
Abstain.
Mr. Transcoso?
John Kusu,
Thank you. Mr. Amar?
Abstain.
Mr. Richards?
Yes.
Ms. Choate?
Yes.
Mr. Vieira?
Yes.
Dr. Dial Singh?
Abstain.
Ms. Dionarine?
Abstain.
Ms. Sipasad?
Yes.
Mr. Timur?
Abstain.
Mrs. Thompson-Aye?
Abstain.
Dr. Dillon Remy?
No.
We have 16 too.
16 noes.
Sure. Just now, because this is the first time.
Honorable Senators, to ensure that the records are accurate, the division will be redone.
No, thank you.
We have to get the records. Yeah.
Mr. Khan,
No.
Mrs. Gopi Schoon, Mrs. Batiste Primus,
No.
Mr. Rambarat,
No.
Mr. Sinanan,
No.
Mr. Moses,
No.
Mr. Hussain,
No.
Miss West,
No.
Miss Cox,
No.
Mr. De Freitas,
No.
Mr. Singh,
No.
Mr. Cummings,
No.
Dr. Henry,
No.
Mr. Dookie,
No.
Mr. Williams,
No.
Mr. Mark,
Abstain.
Miss Haynes,
Abstain.
Miss Amin,
Abstain.
Mr. Sobers,
Abstain.
Mr. Transcuso,
Abstain.
Mr. Amar,
Abstain.
Mr. Richards,
Yes.
Miss Choate,
Yes.
Mr. Vieira,
Yes.
Dr. Dial Singh,
Abstain.
Miss Dionarine,
Abstain.
Miss Sipasad,
Yes.
Mr. Timal,
Abstain.
Mrs. Thompson-Aye,
Abstain.
Dr. Dylan Remy,
No.
Madam President, the result of the division is as follows. 4 members voted for, 16 members voted against, and 10 abstained.
Honorable Senators, the result of the division is as follows. 4 members voted for the amendment, 16 members voted against, and 10 members abstained. The amendment as proposed by Senator Vera was therefore not accepted. We now move on to the amendment as proposed by Senator Thompson-Aye. Senator Thompson-Aye, can we go through at A, B, C, D, E, and F? I will go through A, and then I will get the comments, and we'll do it like that, okay?
A, B. Oh, okay. At A, it should be domestic relationship. That's what I had. It's a typo there. By deleting subparagraph, substituting the following subparagraph is or was in relation to respondent. All I did really is add a person in a same-sex relationship. And as I said in my presentation, it is clear from the Attorney General's own admission that it is part of our Constitution that the government has given a firm commitment that they want to protect the rights of everyone, including those in same-sex relationship, and they've said in support of their case that they have amended the Sexual Offences Act 1986 to reflect a gender-neutral position with regard to the complainant and the victim. It's a human rights issue, and I do not see how this could be sustained. I don't understand the Attorney General's argument with regard to his reluctance or, to cause this amendment to be made.
Any other comments on Senator Thompson-Aye's proposed amendment at A before I call on the Attorney General to respond? Attorney General.
I thank the Honourable Senator for raising quite squarely what is properly a human rights issue. I have no reluctance and no fear to deal with this issue, nor have I been lacking in clarity as to why I am not accepting the amendment at present. For the record, I wish to repeat as follows. I consider this a very important issue that we as a society have to deal with. The only reason that I have not accepted the proposed amendment is that the matter of Jason Jones, which squarely concerned the issue of equality of treatment for same-sex relationships, went to the first instance decision at the High Court and succeeded, went to the Court of Appeal, and from the Court of Appeal will go to the Privy Council. That case concerns two aspects. One, whether the saved law prior to 1962 and prior to our 76 Constitution can still prevail. And secondly, whether it is just or reasonable in a society such as Trinidad and Tobago to not acknowledge same-sex relationships. Because there are 23 other laws that treat with the issue of same-sex relationships, in everything from the Cinematograph Act to the Hotels Act to the Immigration Act. Because there are 23 other laws that treat with that, I accept what Senator Vera said a little while earlier, that the courts are there to interpret our law. But more particularly, the courts are there to determine what is constitutionally fair. It's not just interpretation of law. It is what is just and reasonable in a society such as Trinidad and Tobago within the ambit of Section 13 of the Constitution. Not that it's a Section 13 issue, but it is a rights issue. In those circumstances, my reluctance is not a reluctance. It is a position that I take that at present I cannot advise the government of the Republic of Trinidad and Tobago as the legal advisor to Trinidad and Tobago to amend the law now, because the issue of implied repeal will kick into the 23 other laws. Let me make it abundantly clear. I am not afraid to touch law or human rights issues, nor is our Honorable Prime Minister when that report was approved by the Prime Minister, by the Cabinet. We believe in equality, but we believe that our laws are not designed only by ourselves. There is a process of consultation and there's a process of feedback. That's why the whether laws are just in a society such as Trinidad and Tobago has to be factored, because it's not Faris Al-Rawi's law. And for those reasons, I wish to make it clear, out of the greatest of respect for my honorable colleagues, it's not that there's any afraid issue inside of here. It's an issue of having to be consistent in the approach of law. And that's all that it is. I have set out a very clear path that the Privy Council, which is the highest court of Trinidad and Tobago, will no doubt have to consider this issue, and then a government will be guided by this issue. I want to remind that when we were debating the abolition of child marriage, I raised the very issue of a court striking down child marriage. In this case, it was the court of Tanzania. And in opposition to what was being promoted by the UNC bench at that point in not wanting to support the law, I reminded that a court could strike down a law. It's the same thing that applies in this instance here. So out of the greatest of respect, it is not fair, it is a matter of consistency so that we are guided in a whole of government position.
Consistency with what you said here. Are you going to go back and tell the United Nations Human Rights Council that you made a mistake and all that you said is no longer relevant?
Well, Senator Thompson-Aye, can you now move on to paragraph B, please?
Madam Chair, I must answer what was just put on the record.
No, in fact, I actually was not going to treat with that comment at all. I think that you were given an opportunity to respond, and I'm now asking Senator Thompson-Aye to move on to B.
what I'm proposing at B is to include in the word intimidating as a factor in the emotional psychological abuse. And I use as the example of the client who smashed the things that he owned in the house to instill fear within the heart of his wife. I thought it would be useful to include that word so that if it happens again, that same situation, that hopefully I'll be representing the other side maybe, but it means that the case would not be lost, because certainly it would be a domestic violence offense. It would be clear.
Do you think intimidation will help us? Yeah. Madam Chair, I agree with Senator Thompson-Aye that the inclusion of the word intimidating, because that's essentially the addition, would take us into a better position.
Should I go on to see?
Madam Chair, could I just be guided, please? Because I had also wanted to raise an issue with this particular subsection. Should I do it now or wait until after the vote? Because it deals with the same, it's just the inclusion of the word language to deal with religious coercion and intimidation and so on.
Are you at B?
Yes,
Well, that's what we're treating with, so yes.
yes.
Yeah?
So, through you, Madam Chair, Honorable Attorney General, I was wondering whether we could possibly include the word language in this subsection, language or words or something like that, in this subsection to deal with the issue of the use of religious belief for the purpose of controlling, threatening, intimidating, and so on. I don't know if that is captured elsewhere in the amended version of the Act, but if it is not, I'd respectfully ask you to give consideration to it.
Where? Yeah. So it might be, yeah. But-
May I? Sorry, I thought we were waiting for other contributions. Okay. So, Madam Chair, if I look at this is all the definition of emotional or psychological abuse. And we're deleting that rather limited expression as we had before, contained in the Act. And we've gone for a rather expansive definition. What jumps out at me is Roman 10 on page 10, making unwelcome or intimidatory contact with or acting in any manner described in paragraphs 1 to 5, Romans 1 to 5, and 1 to 5 includes intimidation, abusive, threatening language, offensive material, following the person, depriving the person of use of property, watching or besetting the place where the person resides, works, carries on. And then we get down to towards child, spouse, cohabitant, relative, a person who's in a visiting, dating relationship, a person who is in close relationship with the person. That's actually quite interesting. A person who is in a close relationship with a person, by any means including in person, verbally, or by gesture, letter, telephone, or electronic means. So I thought that we could capture that use of religious belief, although not completely coming towards it, by that broad-based adoption of what in fact is intimidatory or otherwise. My general red flag that runs up in my mind legislatively, where I introduce the concept of religious belief being used as a tool, is that I don't know where to draw that line, particularly insofar as this affects children and adults, and insofar as the freedom of religion is a concept that we have to be conscious of. And even though I think that the Surat principle applies and that this will not necessarily require a 3/5 concern, because it's ultimately for the court to decide if that behavior was something which was offensive, and therefore due process solves the need for a 3/5 majority. I'm sort of concerned about the concept of how to encapsulate the religious doctrine as a technique of abuse. So I hadn't seen it in any other law that jumped out at me, and that sort of tells me be careful.
Just to briefly clarify, it's tied in with the whole idea of how domestic violence takes place in certain circumstances, where you have a man who feels threatened in his masculinity for one reason or the other, whether your wife is earning more money than he is or that kind of thing. And I have had the experience as an attorney where women have been the victims of domestic violence because the man guilt trips her and says, well, I'm the head of the household, so you are supposed to be doing certain things, or you are supposed to be accepting of certain things which may be abusive. So it's not confined to one religion. It is, funnily enough, it's spread across religions. And it is not really religion we're talking about, but it's doctrine. So perhaps I misspoke when I used religion. I only used that because it happened to be in the context in which I experienced it.
Yeah.
So doctrinal abuse. So I was wondering whether the insertion of the word language would afford a measure of protection to such persons.
May I? Thank you, Honourable Senator, for clarifying. I understand it now in the context of an example, and it certainly is a good one. I thought that we had captured it in the context of verbally, and in the particularly if we take on board Senator Thompson-Aye's recommendation, any other controlling, threatening, intimidatory, or coercive behavior towards a person or his child or dependent. I think if we were to put that amendment proposed by Senator Thompson-Aye, I think that the combination between Roman 10 and Roman 12 help us into that zone.
Attorney General, you are therefore willing to accept B of Senator Thompson-Aye's proposed amendments, yes?
Yes, Madam Chair. May I just word check it?
Sure.
And other controlling, threatening.
Any other?
Yes, sorry. I'm just reading left and right hand.
Sure.
Any other controlling, threatening. So now we're adding the word intimidating or coercive behavior towards the person or his child or dependent. Yes. So that effectively is to insert after the word threatening the word intimidating. I don't know how you propose, Madam Chair, because we have C, D, E, and
Yes.
F to go through.
We've just been trying to work it out, and what I think I will have to do is each of these we'll put to the vote and then put it overall. Yeah? So we'll put each but I want to go through because Senator Thompson-Aye may choose to withdraw some parts of her amendment.
Well,
so we're just trying to.
I was just going to assist by saying that if we got to the end where there was a hodgepodge of yeses and nos,
Yes.
then I could indicate what was agreeable, and
Yes.
perhaps the Honourable Senator could make a decision at that point, whether
Yes.
I absorb the amendment or not.
Correct. So far, you seem to be absorbing B.
Yes, ma'am.
Senator Thompson-Aye at C.
Unauthorized, we're really bringing the law into the 21st century here. Unauthorized surveillance of a person, including reading a person's SMS messages, monitoring a person's email account or internet browser history, monitoring a person's account with a social networking internet site, using a GPS device to track a person's movements, and checking the recorded history in a person's GPS device. I think this came from Queensland, Australia.
Yes, ma'am. It is taking us into the modern world, but it's technologically specific, is my fear. Because whereas an 8-track tape, an 8.5-inch floppy, a 4-inch drive, and a CD-ROM and DVD used to be all current technology, they're no longer in use. All of this really gets down to behavior. And I really wanted to not accept. We did look at New South Wales, Queensland, and Australia in general, and we didn't want to go for the technological specificity of language and instead to look at the issue of behavior. So may I respectfully not accept the recommendation only because it's too technologically specific and can be caught under behavior.
Can be. Which one would it fit into?
It would fit into Roman 12, Roman 13, Roman 10, Roman 6,
not 10,
Roman 5, Roman 3, and Roman 8.
There's no contact, though.
Roman 8, for example, making
it's just-
unwelcome
it's
or
surveillance.
intimidatory contact with a person by any means, including in person, verbally, or by gesture, letter, telephone, or electronic means.
Surveillance is not contact. You're away from the person.
Let's see if we can find surveillance to park anywhere inside of here.
It's not parliamentary language, but it's really macroing.
Yeah, but that's a physical limitation from place to place. You see, Madam Chair, my difficulty with electronic surveillance, quote unquote, is evidence. And more particularly, how can it be abused? Let's suppose somebody we had this huge problem in the Cybercrime Committee, entering or remaining in without authorization to a system, cloning of phones, all of these aspects. We ran into the technological difficulties which the Budapest Convention, Senator Mark has had a lot of concern over that particular convention. And then when you look to the UN aspects. So my problem is, what about an innocent infringer? How do I catch that? So my alarm bells are ringing on technological specificity, and I prefer to go for the court to interpret the behavior, the intimidatory behavior, the pattern of conduct, etc., which can be tantamount to domestic violence.
Thank you, Madam President. Through you, with regard to Roman 8, Honorable AG, would the word uninvited and unauthorized instead of unwelcome be offensive to you? Because unwelcome is so subjective as opposed to uninvited or unauthorized.
I think it's the intent to have a degree of color to it, if I could put it that way.
What does that mean?
Unwelcomed means more than uninvited, because something may be uninvited and welcomed, as opposed to something being both.
I haven't gotten your trend of thought. Apologies.
So, for instance, if an attractive young lady comes up to me and says certain sweet things to me, as my
Yes,
wife did many
yes,
years
let's use
ago.
another analogy.
It may have been uninvited,
No,
but it may have been welcomed.
I think I'm lost at this stage.
He's looking at Roman 8, Madam Chair.
I know. I think someone else needs to give a distinction between uninvited and unwelcome.
Appreciate that because to me, I have a different interpretation of unwelcome. Uninvited is more decisive to me.
So if someone, Senator Richards, you're having a party and somebody who's uninvited turns up and you look at them and you say, oh Lord, you're not really meant to invite you and I didn't, but come in. Welcome. So he's uninvited, but he's not unwelcome. You know what I mean? Isn't that what you're trying to say, Attorney General? Take out the ladies and leave this.
Madam Chair,
Let's go with the party.
let me be specific. Madam Chair, if I could just qualify, the reason why I make reference to ladies is that I'm a twin. I have a twin sister. So forgive me, I have a perspective of both of us. It's always us and not I. So if I put it this way, the reason that we went for unwelcomed, when we're discussing the sexual harassment law, which we have been in discussion with, the question of a Trinidadian whistling at an attractive person, because it goes both ways, became a position. That was an uninvited issue. The question was whether somebody had really crossed the line to the point of it being unwelcomed. So I do see a distinction between uninvited and unwelcomed in our society.
True, but if that's the appropriate legal term, I'm fine with it.
Madam Chairman,
Yes, Senator Me.
I just want us to be mindful that this
Could
bill
you-
does
could you
not
speak
only
up?
deal.
Senator Me, not hearing you.
I just want us to be mindful that this bill does not only deal with domestic violence between two persons who are in a relationship. You also have children and elderly persons coming into the mix. If I, as a parent, from time to time check my children or my spouse, my children's whereabouts via the GPS on their device, whether it is a cell phone or iPad and so on, there are many parents who track their children using apps on their devices. Any child, a rebellious teenager, is now empowered by this law to go and report that parent, and they will be committing an offense according to this act. So I think it's very important that we clearly define this idea of surveillance, unwanted surveillance, because it is an issue, because it can be used for intimidation as opposed to being used for protection and safety. So even if it means coming back to this and getting a proper phrase to define it, I think it's important that we properly address it without allowing the space for abuse by, for example, a rebellious teenager who is tracked by their parents using GPS on a device.
Any other
I just
comment
wanna say,
on?
I quite understand what Senator Amin said, and although there's a right to privacy in the child, there's also a right, of the parent to safeguard the child, and there's a lot of case law on that. So I don't think that is an issue that would arise in the circumstances where there is justification. We could have this discussion outside, but.
Senator Choate?
I don't know if you put lawyers in a room and each one will have a different point of view.
So true.
But I understood Senator Amin to be supporting the proposal by saying when you specify and say it's unauthorized, it means that a parent is authorized. So the parent is protected from any complaint made by or on behalf of the child. In addition to which, Honorable Attorney General, again, we have to return to the demographic that we're dealing with, which is at highest risk. And unfortunately, there have been so many instances of one party tracking the other by not only checking their phones to see who they're talking to or messaging and that kind of thing, but also finding their whereabouts, which is pretty dangerous because it means that if you could find the person's whereabouts electronically, you could also find yourself there with a weapon. So I think there is some merit, or there's a great deal of merit to having this set out in this way. And certainly if it is an issue that the courts will have to grapple with, the courts will grapple with it as they have grappled with many other descriptions of electronic evidence.
Yes.
Thank you, honorable senators. First of all, may I just genuinely say I really do appreciate the perspectives being volunteered. I know we're all trying to get to a better law. Please don't take anything as sharp disagreement with any personality. I welcome the perspectives. How about, well, first of all, I will remind that the definition emotional or psychological abuse includes. So the chapeau is any act or omission or pattern of behavior of any kind, the purpose of which is to undermine the emotional or mental well-being of a person who is in a domestic relationship with the respondent. And then it says including. So we don't say the word means to put it limited. But catching nonetheless Senator Thompson-Aye's modernity and also the last submission coming from Senator Choate. Perhaps at Roman 5, if we were to look at an amendment which looked like this, and I'm just going to say it aloud, Madam Chair. Just after the word the and before watching, the surveilling, watching or besetting of the place where the person resides, works, carries on business, or happens to be by electronic, by any, including electronic means. By electronic or any other means. That could probably capture that context of, well, Parliament in its wisdom didn't intend that electronic surveillance was out or in.
Why don't we simply say then, by any means whatsoever?
We could. I was trying to capture the Thompson-Aye, Senator Thompson-Aye's position of the electronic.
Yeah,
But by any means
would
whatsoever
be electronic.
would take us out of the technological specificity. Yeah? So, Madam Chair, then, it would be, and God knows whose amendment this will be, but it would be in Roman 5, after the word the, inserting the word surveilling, it'll all continue down to the end just before the semicolon, by any means whatsoever. Or do I even need it whatsoever? By any means. Just by any means. Thank you, ma'am.
Sub 5, including the word surveying. Surveilling after the, so the surveilling, and including the words after happens to be by any means.
Where it is happens to be by any means doesn't fit as I want. Besetting by any means before of the place? It would fit better there rather than coming and qualifying happens to be by any means. It's a different meaning altogether.
Attorney General.
Well, the CPC's view is that we put by any means at the end to capture the widest import, as opposed to a justem generis, words qualifying towards the end. You think?
Sorry, you wanted at the end?
So CPC saying an alternative could be after the word besetting, we could put by any means.
That's what Senator Thompson was suggesting.
Oh, I'm sorry, I just didn't know where the Honourable Senator was locating it. I apologize.
No, that's all right.
Apology accepted.
So, Senator Thompson, having said that, will you therefore withdraw your proposed C in your amendment?
I'm just checking on the word that he used there.
Senator Vero?
Thanks, Chair. I'm just thinking if you're going to use the word surveilling, you don't need watching. It becomes redundant.
I'm looking up that word actually, Senator Vale. It's not within my vocabulary.
I kind of got the idea that watching was slightly different from surveilling because it included a I'm there and watching you, as opposed to surveilling, which could capture the electronic watching and tagging.
X11 from your list, from your amendments to clause 3.
And adopt the Attorney
Yes.
General's recommendation.
Yes.
For now, until I check to see that that is a proper word. Yes, I will. I reserve the right to come back if I don't find it in the dictionary.
And can we move on to your E?
Oh, this was I think we discussed this when we were discussing Senator Vera's first proposal, a relationship where the applicant and respondent share or shared the same residence or co-tenants. I think the same arguments would apply. What did we do with that? Did
So
we accept
in
that? We
light of
voted
that, are
against
you
it?
withdrawing it?
Member of the same household by relation where the applicant and respondent share or share the same residence. I'll take my chances. I want to draw it at this stage. I will hear what others have to say. I will not withdraw it yet. I'll hear what the others have to, if there's any.
Well, could you therefore indicate the basis of the amendment proposed at E, please?
The basis of the amendment is that it was, what we had was not capturing the reality of life where people, I say, they exist, they coexist in relationship which does not involve a blood relationship or one by marriage, but they live in the same household.
Anyone else wishes to speak on this before I ask the Attorney General to respond? Attorney General.
Thank you, Madam Chair. I do understand.
Senator Amin.
Sorry.
Yeah, Madam President, one of the things that I mentioned in the debate, I don't know if it will...
I'm sorry, I'm not hearing you.
One of the things I mentioned in my contribution, and I'm not sure if you want to take it on board at this point, is what I referred to as Caribbean relationships. I am aware that there are situations where, for instance...
Sorry, what relationships?
Caribbean relationships.
Caribbean.
Yeah.
Yeah.
I am aware that, for instance, I've had encounters where a woman who I would call the abuser lives in a house with her partner, a man, but next door lives her brothers or other male relatives. And when they have an argument, the brothers would intervene and beat the man. he is a victim of abuse. And it is domestic because it comes from her directive, she as his spouse. But she's not physically doing the abusing. But the relationship of a person living next door or in another that is not in the same home is not captured. That is one instance I wanted to raise. And the other one is where you have a child that is not a child of the relationship, as they say here, is not adopted, might just be a child who is living with you because there's your Makome child and you're taking care of the child. Is your godchild or is some auntie friend child living with you. So there are children who are not related, not adopted legally, but are living in a home and may experience abuse.
Yes, Senator Mark.
I said I'd like to support what Senator Amin is saying. And through you, Madam Chair, I can raise with the Attorney General this category of persons who are living in the same house, but they are not related by blood or affinity. They could be boarders, people come into, board, as the case may be, where they live in, friends, dependents, but they can become subject to domestic abuse. So I just wanted to ask the Attorney General, how do we treat with those individuals who are not blood related or there's no affinity?
We are treating with Senator Thompson I's
and
proposed amendment at
same household.
So right, okay. Attorney General.
Thank you, Madam Chair. So, Madam Chair, the person who lived as the abuser and who had her brothers come across and beat the man is caught under domestic violence. That person has caused someone else to carry out their intimidatory or physical or other positions, and the law clearly captures that. Secondly, those people will also be responsible under law, under several other laws, the Criminal Law Act, the Common Law, what offenses against the person, etc., harassment, etc. With respect to the child, we have taken the most expansive definition of child now to include a child being someone caught under the person who has responsibility for the child. So what we did is we borrowed the term from the Children's Act number 12 of 2012, a person with responsibility for the child, i.e. a godchild or any other child or looking after the child. All of those people are caught under this law because we capture the concept of having care and custody in any form or fashion with responsibility for the child. So that child is caught and protected in those circumstances. With respect to Senator Mark's inquiry as to people who are not in the same household with the degree of affinity, we'd have to go back to the definition of domestic violence. Domestic violence is then triggered to the definition of domestic relationship. Domestic relationship has multiple avenues to it: visiting relationship, dating relationship, vertical arrangements to people who are reliant upon elder situations, downward relationships, vertically downward relationships to children, horizontal relationships in degree of consanguinity or affinity, and adults who then find themselves in the category of the dependent bracket. So it's a fairly wide bracket. In Section 6 of the Act, as we cause it to be amended, just to underscore the point to Senator Amin, Section 6(1) we amend to include causing or encouraging another person to engage in conduct referred to in 1 to 7. And that is, of course, all of the grounds of beating someone or coercing them, etc. So we've caught all of the aspects to this.
Attorney General, and in response to Senator Thompson,
Senator Thompson, I responded to previously. Is there something further that I missed, Madam Chair?
Okay, so you've responded to her proposed amendment at E.
So, Madam Chair, what I would like to do is to go a little bit further than I had suggested in the Roman 5, because if we look to that amendment, and if you just permit me, this is page 9 of the bill. In Roman 5, I had suggested trying to capture Senator Thompson-Aye's recommendation that we insert the word surveilling, comma, after the word the, watching or besetting by any means, and I would like to include now, of the person or of the place. So that we capture both the surveilling of the person and the place, which would capture that whole GPS and tracking and other positions recommended in Senator Thompson-Aye's C. So if I could repeat it, it is after the word besetting by any means of the person or. After the word the, first line.
And you've dealt with E.
Well, yes, Madam
Great.
Chair. E is a recitation of the previous discussion that we had in relation to both Senator Vera and Senator Marks' earlier concerns.
Sure. So Senator Thompson-Aye. Well, before...
I got by any means?
By any means of the person or.
The surveilling, watching, or besetting.
So it will read the surveilling, watching, or besetting by any means of the person or of the place where the person resides.
And down to the end.
Yes.
That's fine. I accept surveilling sounding good. Thank you.
So Senator Thompson-Aye, let's just now, we've dealt with all aspects of your proposed amendment. The question to you is, the Attorney General has indicated that the amendment proposed by you at B, he will, to use his words, absorb. Do you still wish to pursue A, C, D, E, and F?
A. A, C. So he accepted B, so we just have the C, E.
I've accepted C insofar as I propose an amendment to Roman 5 at page 9. So effectively, Madam Chair, if I may, I agree with the amendments proposed in paragraph B.
And you've adjusted?
I've adjusted the amendment proposed in paragraph C by absorbing it in Roman 5.
Correct.
Yeah, that's fine, yes. I accept what he said
And
with the amendment as proposed.
do you wish?
So I will, yes, I will withdraw and go with his. Go with the Attorney General.
So you're withdrawing
Yes, I will.
A?
No.
So therefore, what I will have to do is to treat with Senator Thompson-Aye's amendment in two parts, okay? So we will deal with A first, and then we will deal with B. You have withdrawn C, E, and F because the Attorney General will subsequently amend 5.
All right.
Are you withdrawing C, D, E, and F, Senator Thompson-Aye?
E and F? I don't know what the F is.
E and F is the renumbering.
Yeah.
That's fine then.
So it's really C and F.
Yes,
C and
I feel confident, Madam Chair, that E will come in a miscellaneous provision before very long. Not be and he nods.
so you're withdrawing all of it but A
Yes, please.
and B, correct?
Yes, please.
So, honorable senators, the question is that clause 3 be amended as proposed by Senator Thompson-Aye at A in her list of amendments. Those in favor say aye. Those against say no. No, respectfully. I think the noes have it. Sure. Not yet. Everybody has to come. Oh, people left. Yeah. So, on A, 3A. 3A? In Senator Thompson-Aye. Which deals with the same-sex relationship, that A. Just A. Just A. Yes. Amendment. All right, I think we are in a position to begin the division. Yes? If anyone comes in while the vote is being conducted, their votes will be recorded. I want to remind senators the division is on clause 3A as proposed by Senator Thompson-Aye and circulated. That's what we're treating with right now.
I think there's a little confusion because all I'm doing is adding 3, the other 2 are already there. The way this is worded, you know, it
But we
doesn't
have
seem
to
very
go
clear.
on what you have worded in the amendment here. So it is 3A. You've just explained that the only difference will be at B3 in 3A, correct?
That's right.
Yes.
All these adding.
Thank you.
Mr. Khan,
No.
Mrs. Gopi School,
No.
Mrs. Batiste Primus,
No.
Mr. Rambarat,
No.
Mr. Sinanan,
No.
Mr. Moses,
No.
Mr. Hussain,
No.
Miss West,
No.
Miss Cox,
No.
Mr. De Freitas,
No.
Mr. Singh,
No.
Mr. Cummings,
No.
Dr. Henry,
No.
Mr. Dookie,
No.
Mr. Ma,
Abstain.
Miss Haynes,
Abstain.
Miss Amin,
Abstain.
Mr. Sobers,
Abstain.
Mr. Trancuso,
Abstain.
Mr. Amar,
Abstain.
Mr. Richards,
Abstain.
Miss Choate,
Yes.
Mr. Vieira,
Abstain.
Dr. Dial Singh,
Abstain.
Miss Dionarine,
Yes.
Miss Sipasad,
Yes.
Mr. Timo,
Abstain.
Mrs. Thompson-Aye,
Aye.
Dr. Dillon Rami,
No.
Sina here. 450. Madam President, the result is as follows. 4 senators voted for, 15 members voted against, 10 members abstained.
Honorable Senators, the result of the division in respect of the amendment proposed by Senator Thompson at 3A, 4 senators voted for the amendment, 15 senators voted against it, and 10 senators abstained. The amendment has therefore not been accepted. We move on to B. As circulated, the Attorney General has indicated that he is accepting the amendment as proposed at B, correct?
Yes, ma'am.
Honorable Senators, the question is that Clause 3 be amended as circulated by Senator Thompson-Aye in respect of B, paragraph B. Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. The amendment as proposed by Senator Thompson-Aye at 3B is accepted. I'm not going to the forms for the bill yet because we're going to deal with the Attorney General and go to all. We now move on to the amendment as proposed by the Attorney General, to Clause 3.
Madam Chair, in the definition of child, 3D, as it appears in the bill, we are simply correcting an inadvertent cross-reference, and therefore the amendments are as circulated, replacing Roman 3 with Roman 4 instead. Madam Chair, I also propose, in so far as Senator Thompson-Aye's amendment was withdrawn and I agree to accept it, that we further amend at page 10,
9.
9, forgive me, at page 9, Roman 5, that we amend Roman 5 by inserting after the word the, surveilling, comma, and then after the word besetting, the following words, by any means of the person or. And the rationale for that is pursuant to the discussion we had on Senator Thompson-Aye's recommendations.
So, Honorable Senators, the question is that Clause 3 be amended as circulated by the Attorney General and further amended at page 9, sub 5, by including the word surveilling, comma, by including the word surveilling, comma, after the, and including the words after the word besetting by any means of the person or. Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. Honorable Senators, the question is that Clause 3, as amended, now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 3 as amended now stands part of the bill.
Clauses 4 and 5.
The question is that clauses 4 and 5 stand part of the bill. The question is that clauses 4 and 5 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 4 and 5 now stand part of the bill.
Clause 6.
The question is that clause 6 stand part of the bill. In respect of clause 6, amendments have been circulated by Senator Richards, Senator Vera, and Senator Thompson-Aye. Senator Richards.
Thank you, Madam. Through you to the Honorable Attorney General, and I apologize if I am clumsy in my explanation because I'm not a legal draftsperson. I depended heavily on the Parliament resources to craft this. The insertion is after 5 of the Parent Act, which provides for the surrendering of weapons upon a complainant's issuing of a complaint. And it is absent of specifying members of the Trinidad Tobago Protective Services, including members of the TT Police Service, Trinidad Tobago Defense Force, Trinidad Tobago Coast Guard, and private security personnel who hold firearm licenses. It follows legislation in South Africa where it is very specific about this because they also provided for surrendering of firearms at the insistence of the court or the assessment of the court. And in their case, and sometimes in our case, to my knowledge, police officers or members of the protective services were not necessarily captured by the understanding of the Parent Act as it stands. So my suggestion is the insertion of the word either personally or in his capacity as a member of the protective services, including members of the Trinidad Tobago Police Service, Trinidad Tobago Defense Force, Trinidad Tobago Coast Guard, and private security personnel who hold a firearm license to protect complainants in these circumstances.
Any other, in your other paragraphs to clause 6?
I think the others are consequential to this.
Any comment on the amendment proposed by Senator Richards before I ask the Attorney General? Senator Sobers.
Just on a point of clarity, Madam Chair, through you to Senator Richards, are you then asking that these individuals that you have named here, the FUL that they would have, because what happens with these types of persons, they would have their FUL. Some of them may have FULs for personal carry, but then they may also be issued license. They may also be issued firearms to carry based upon the job that they do. So what are we asking them to give up?
The suggestion is for them to surrender the firearms as it's placed either personally or in their professional capacities. So whatever weapons, that's the intention. It may not encapsulate in the wording, but that's the intention.
Senator Choate?
I don't like disagreeing with Senator Richards, but I do have a certain amount of caution in my mind about this, simply because in the situation described by Senator Sobers, it would mean that an officer who is precepted for his job and thereby allowed to carry a firearm will now have to surrender it, and that will take away his capacity to earn and perhaps maintain his children and have a lot of, serious other consequences. And this is before he's convicted or before the magistrate has come to an adjudication on the matter. If it is after the magistrate has adjudicated, then it's another thing. But this is before the magistrate has adjudicated, or the court has, I beg your pardon, the court has adjudicated. The second thing about it is some of the TTPS officers have personal firearm users licenses, and that is because they are witnesses in cases where threats have been made to their lives very real threats have been made to their lives. So in balancing this off, as much as I would like to support this proposed amendment, I think perhaps it may not be the best thing to do.
Madam President, what I understand, Senator Choate's intervention, by my understanding of the Parent Act, but the court may is the intro to this, so to speak. If I'm not mistaken, Attorney General, it will be on the assessment of the judicial officer if the complaint is assessed by the judicial officer as serious enough to put that the complainant is assessed to be in danger from that officer. So there's some judicial intervention in that, in making that decision. And just to complete, and I fully understand the situations, and I support Senator Choate's intervention that officers are in dangerous positions, and we should not in any way put them in more dangerous positions by flippantly removing their ability to protect themselves. But it's also in the interest of the context of this Domestic Violence Act, where we have seen situations where officers have threatened and in some instances shot at each other and have killed their spouses or their companions.
Senator Sobel.
Senator Richard, through you, Madam Chair, the thing is, what I don't, just from listening to the committee stage just far, what I think honorable senators have to also understand, remember there can be interim orders that are made where the respondent can also be ejected from the home for a particular period of time. And even if it is we were to go as far as indicating that, okay, let's say we take away the firearm, the individual could still commit a heinous act with a knife or a cutlass, which would be readily available. So that surrendering possibly and as you think, Senator Choate is correct, there are many officers who may be precepted and would carry a weapon whilst on duty. But because of, apart from maybe having a threat made to their life, because of the particular unit that they may be involved in, the specialized units within any of these arms of the defense services, to remove that ability for them to protect themselves, apart from going home or just, driving about or natural daily activities. I mean, when we balance it out, I mean, it is based upon an allegation at that juncture. There could be other things the court could utilize, as I indicated, the ejection, in order to eject the person from the premises pending the outcome of the matter. It's 30 days, but you could get it extended. I think there's sufficient protection in place, especially for these individuals, to ensure then that the applicant is properly protected during the period of time that the court matter is being dealt with.
If I could hear the Attorney General, I'm on the borderline.
Thank you, Madam Chair. So the mischief that we're trying to catch here is somebody who has a dangerous weapon lawfully, either in personal possession under a firearm user's license, a firearm employee's certificate license, FUESL, sorry, or as a member of the defense force, etc., protective services, being in possession, being put out of possession because of the circumstances of domestic violence. So whilst the amendment proposed by Senator Richards is not contained in the bill itself, it's actually an addition that the Honourable Senator is asking us to do, to amend, in fact, Roman 5 of Clause 6 of Section 6. Section 6 says a protection order may direct that the respondent relinquish to the police any firearm, license, firearm, or other weapon which he may have in his possession or control and which may or may not have been used. That's the existing law. So the existing law provides the remedy to that which is sought here. What is being sought here is a step further to say, well, look, this should apply to you if you are a policeman or a member of the defense force, etc. But respectfully, that's where any person is involved, because a respondent is not disaggregated by his job. In other words, then a respondent may be a policeman, a member of the defense force, etc., and therefore the power of the court to direct that he relinquish to the police such licensed firearm or etc. is still inherently in existence here. The reason that I think we ought to exercise care and caution has been very capably put by Senator Choate and by Senator Sobers in terms of the balance that we have to have on these things. And I think Senator Sobers really hit the nail on the head a little while ago when he raised the position that we may in fact be ex parte, one party alone, order granted, etc. But I think we need to exercise care and caution because we do know that in the balancing act that there are also false allegations that happen. I'll just remind that the Commissioner of Police in the issuance of licenses also has a general control over the whole use of licenses. And a license is not an absolute right. It can be withdrawn at any point. The TTDF has a regime where they consider risk assessments. The TTPS has the same aspect as well. And if we go later on into the amendments proposed in respect of bail at Section 27 of the Act, insofar as a protection order might lead to a consideration of bail, not in every circumstance, obviously. The fact that we're now adding in the new 1A, the power of the court to ask for a risk assessment, we're then getting much, much closer to where we have never been before. That risk assessment feeds, do you keep your licensed firearm or not? Are you a risk in the police service or defense force or not? And then the other laws which articulate with this will then come to save us. So I respectfully believe that the existing law captures it well enough.
That's the wonderful thing about dialogue. Madam Chair, under those circumstances, I am comforted and I withdraw.
Thank you very much. Senator Thompson-Aye, can we deal with your proposed amendment to Clause 6?
Thank you, Madam Chair. What I'm seeking to do here is to add to the orders that the court can make by proposing it's always confusing when you do it like this because I have not interfered with 1. My proposals are in respect of 2 and 3. The child attends specified counseling at the respondent's expense. In the original legislation, we had the applicant also attending counseling. I think now we're having the respondent attending counseling. And I'm suggesting that because of circumstances I mentioned earlier in my presentation, that the child may need this special care, this special counseling, and that the respondent who has caused the child to be in this bad place, that he should pay for it. And the other one is that a police officer or other court officer within a specified period of time accompany the applicant, respondent, or a specified person to the applicant's residence and supervise the removal of that person's or another named belongings. Many times, if the applicant is leaving the premises, we would normally, as lawyers, write a letter to the police officer in the district and ask that the officer, well, of course, is almost like a favor, assist the applicant to remove belongings from the premises. And if it is written into the legislation, it would certainly give more force and, leverage to the applicant who would need this, and it would assist the police in moving faster to assist the applicant. It's in that scenario that I propose these amendments.
Anyone wishes to say anything before I ask the Attorney General to respond? Attorney General.
So, Madam Chair, I think Senator Thompson-Ayi has hit a very important issue. In the amendments that we propose to Clause 6, Clause 6 proposes an amendment to Section 6 of the Act. And Section 6 of the Act is where we deal with the terms of protection orders. In our amendments, we have made the recommendation coming from the committees in subclause in B, Section 6, B, Roman 8, that the respondent receive professional counseling or therapy from any person, agency, or program which is approved by the minister in writing. And Senator Thompson-Ayi, if I please, and I ask the Honourable Senator to correct me if I've got this wrong, is now saying, well, what about the applicant and child, essentially? Because they too may be in need of counseling. Insofar as the protection order is directed at the respondent in the manner that we have phrased it, both in respect of 6.1a, 6.1b, then we get into C, direct that the applicant immediately occupy any place or residence, whether or not the residence is jointly owned. And then we say in 1a, the court may refuse the respondent contact, order structured contact between the respondent and child. So the question is where one ought to treat with the counseling aspect to child and to applicant. And I think the Honourable Senator is right that we need to provide for that.
I'll come in first.
So you received them for them.
Yes.
Where should we park it? Madam Chair, I think Senator Choate wants to help me out.
Senator Choate.
I was wondering, does not the original section provide for both parties receiving professional counseling or therapy and ensuring that reasonable care is provided in respect of a child?
Yes, the
7 and 8?
Yeah, the original Section 6 was structured such that the protection order may A, prohibit respondent from a category of things, and then B, direct an order be applied for the benefit of the child or dependent, and C, direct that the respondent return. And then Roman 8, or applicant or both receive. So it was oddly drafted insofar as 6.1c said, direct that the respondent or applicant or both. So they merged it in from the chapeau to the body. And I do think that we need to keep that concept of applicant and add child, if necessary, into that. So I'm just leaning over to the CPC to find an appropriate structure for that.
removal of that. If I may.
Madam Chair, permit me to just put this on the record. The stakeholders, in their very large numbers, indicated that they did not want the applicant to necessarily be the subject of counseling, and I'll tell you why. The data that comes out of it in the experience of the Act over the last 21 years has been that applicants, according to the stakeholders, were pushed into the zone of not wanting to pursue their applications because they were directed towards counseling. I myself have a little bit of difficulty with that, just to let you know, but the experience coming from the practice was that. The argument can be put, and here's where we need to exercise caution, that the court has an inherent jurisdiction, particularly when you're dealing with the Family and Children Division, and we deal with the Children's Court. And because in Section 3 of the Family and Children Division Act, we define a child matter as specifically including a protection order or domestic violence application, etc., etc., and that the court has powers under that to act in and of its own accord. The argument is that the court has the power under the Children's Act to do that, under the Children's Court to deal with that. The protection order itself directing that the applicant and the child and the respondent, all three, be the subject, is where the stakeholders came forward to say, look, let us have this matter determined. If you notice, later on when we looked at the amendments in the bill, in the Act, we're really saying no more extension of interim orders, for instance. We've taken that out to say determine the matter once and for all, so it's not lingering, which has been the experience in domestic violence matters. So we accepted the point of view that the court had the ability in other circumstances to order the counseling, particularly in the children's regime, and under its inherent jurisdiction to order someone for counseling if they so chose. The question is, how does the Senate feel about that? Because ultimately it is the Senate on this occasion here, this House, that makes the law. I can see merit in keeping the applicant and child with reference to counseling. It furthers the overriding objectives of the family proceedings rules, the children proceedings rules, and the civil proceedings rules. One could even say the criminal proceedings rules as well. The question is the stakeholders being adamant that there was a discouraging factor to the applicant in the applicant being sent for counseling.
Wanted to say something?
Just on that point, I was going to deal with it in one of my later amendments, but just for the record, I've seen many situations where you're trying to deal, a family's trying to deal with a child who is wayward, or they have a family member who is bipolar, or who has a psychological illness, or who has a substance abuse problem. And that person then goes and makes an application for domestic violence against the people who are trying to care for him or her. In such a situation, I think the court should not be preempted from having the opportunity to say, you know what, on this demonstrative evidence, I think I would also like to have the applicant assessed.
Senator Choate?
Thank you, Madam Chair. Thank you for the opportunity. I agree that there have been similar instances which I have encountered in practice where there may have been need for some sort of counseling or assistance to the applicant. I think perhaps what the stakeholders are thinking about are the situations where the counselors, instead of trying to address the harm done to the applicant by domestic violence, the counselors then try to do marriage counseling to say, well, you should get back together, you know, that kind of thing. But perhaps that difficulty could be alleviated if the court makes it clear in identifying the counselors, because now there are lists of counselors who are acceptable to the court, in identifying the appropriate person the court may be able to alleviate that danger.
Madam Chair, I'd like to accept what my colleagues say. It seems that it is by far a better option to preserve the opportunity and train the court up and the ancillary services to the court. So that would mean that Section 6, Clause 6, A, Roman 3, which proposed renumbering paragraph C as B, in paragraph B as renumbered, in Roman 6, in Roman 7, in Roman 8. So in subparagraph Roman 8, by deleting before the word receive the words or applicant or both, we should abandon that. What we should really be doing is to adding the word child in a different form. So it should be or applicant, comma, child, or applicant or child, or all. Just let me get that language correct.
Well, this clause is directing the respondent. That's the chapeau, as you call it.
Sorry. Madam Chair, I missed what Senator Thompson-Nye was saying.
Pardon me?
I missed what you were saying, sorry. May you remind the Attorney General, and then I didn't catch the rest.
Coming down the heading, what is saying, the protection order may direct that the respondent, and everything here, going on to where we are now, is directing the respondent. It doesn't say direct, it says direct that the respondent. And I think there may be a question of agency, because sometimes what comes across to the applicant who has reached a place where she can now approach the court, say, you better go for counseling. So she feels she's damaged goods, when she really thinks that she's been doing all right, and it's he who has the problem, and he should go and get the counseling. There's always, the court can always direct or give advice. And in the other amendment that I have, the police could advise her where she could get support services. But I don't think that we need to put back in the applicant here. I wasn't at the meeting, but I don't think we need to put back the applicant here.
Madam Chair, I thank Senator Thompson-Nye for her observation. I had raised it in my observation on the architecture used in the original act in Section 6C, Roman 8, saying that they had found a way to go beyond respondent and included applicant. But if I could do surgery to the bill itself now to capture the concern raised by Senator Thompson-Nye, because it's effectively that the applicant and child, and meaning or, could be referred to counseling. At page 17 of the bill, Madam Chair, at paragraph C in the middle, in subparagraph Roman 8, it would be, instead of the words that you see there, it would be by deleting, if you strike the word before. Let's make sure that we capture this. Page 17 of the bill?
Yes.
Yes, it would be, so to read as it is, by deleting before the word receive, the word both. So it wouldn't be or applicant or, strike the word or, applicant or. So it'll be by deleting the word in inverted commas both, and inserting the word, and substituting the word, open quotes, child. So should it be or child? Or stays, right, okay, child. So it'll be C as written there, in subparagraph Roman 8, by deleting before the word receive the word both and substituting the word child.
And has that gone?
No, I'm sorry, I was capturing the issue
All right,
child.
Attorney General,
Yes, Madam Chair.
Senator Thompson-Aye, there's a procedural matter to be treated with.
Sure.
So that the Senate will now resume. The committee is suspended and the Senate will now resume.
I beg to move that the Senate continues to sit until the completion of the business at hand, inclusive of the matters concerning the bill and the motion for the adjournment. Thank you.
Senators, the question is that the Senate continue to sit until the completion of the business at hand, including the matters on the motion for the adjournment. Those in favor say aye. Those against say no. I think the ayes have it. The Senate will continue to sit until the completion of the business at hand, inclusive of the matters on the motion for the adjournment. Honourable Senators, the committee proceedings, we shall now resume the committee proceedings. Attorney General, Senator Thompson-Aye, Attorney General, you are proposing a new form of amendment in respect of what Senator Thompson-Aye has proposed. Am I right?
Yes, Madam Chair, and this comes out of Senator Thompson-Aye's observations to Clause 6.
Sure.
But I had only gone to part. So may I be permitted to respond to Senator Thompson-Aye?
Sure. I just want to say one thing. It is now 7:45. We started the committee proceedings at 5:25. We're on Clause 6 of a bill that has 31 clauses, and we have several sets of amendments. So I really am going to plead with everyone to be as alert as possible as we go through this, and to also be as succinct as possible in presenting your comments and your observations. Senator Thompson-Aye.
I've spoken
Do
to
you
my...
have this, right? Yes. What he's saying. In general, you wanted to ask Senator Thompson-Aye something?
No, I wanted to respond to her submissions. I thought that she had completed. Am I wrong?
Senator Thompson-Aye, have you completed your submissions in respect of your proposed Clause 6, the amendment to Clause 6?
Yes, I have. I am still trying to understand the formulation from the Attorney General, because what I was saying is that if it is a protection order may direct that the respondent, and there's a list of things that the respondent can do, then to suddenly come in and say the child You can't have direct respondent that the child, do so and so.
Attorney General,
So
is that your question, Senator Thompson? I saw the Attorney General will respond now.
Thank you, Madam Chair. Madam Chair, Senator Thompson-Aye's amendments effectively go to the manner in which and the elegance by which we capture treating with the applicant and the child. The original act, as set out at Section 6, set out at Section 6C that the court could direct that the respondent, and then it went to Roman 8, or applicant or both, receive professional counseling. So we went with the existing structure of the existing law, which has been there for many years. We had proposed that only the respondent get counseling. Having heard what Senator Thompson-Aye says, I think we were wrong. I think we ought to agree that the applicant, and more than the applicant, that the child be the subject of potential counseling. Senator Thompson-Aye has also proposed, so you'd see that in Roman 1, that's effectively what is there already. It's Roman 2 that Senator Thompson-Aye, in her circulated amendments, captures the child. So I agree with that. Roman 3 is that the police officer or other court officer accompany. And what I'd like to say is that Section 6.6 of the existing law already captures that. So what Senator Thompson-Aye puts in 6 Roman 3, that's part of the existing law in Section 6.6. What Senator Thompson-Aye proposes in Roman 2, I agree to accept in a formulation of words which I will offer. And Roman 1 is effectively the same as what is inside of the bill. To answer what Senator Thompson-Aye is now asking me about what formulation I was proposing keeping with the existing law and looking at the bill as we propose the amendments to the existing law to happen, to capture adding the child. I propose at page 17 of the bill, at paragraph C, in subparagraph A as in apple, that the wording instead be adjusted as follows. The correct text should be as follows. By deleting before the word receive, the word both, and substituting the word child. And that would capture what Roman 2 of Senator Thompson-Aye has proposed.
My recommendation,
No.
or are you just going with it as is?
If I could say why, because then that would mandate the court in circumstances where the court or the state could actually offer the counseling. So I would think it unduly restrictive to just say at the expense when the state may very well provide it gratis.
That's fine.
Senator Thompson-Aye, will you withdraw your proposed amendment to clause 6?
As soon as I've heard the Attorney General's, amendment.
You just heard it in respect of, I haven't put it as yet,
all right.
but the Attorney General has put on record what it will be. And so therefore, at the appropriate time, I will introduce it.
Very well.
Yes, so you will withdraw your proposed amendment to clause 6. Senator Vera, you also circulated amendments to clause 6.
Thank you, Chair. So I'm on page 17 of the bill. I'm looking at what would have been what we were just talking about, where you are directing the respondent. I was going to suggest that we insert at 6B a new 10, that the respondent, I didn't put the word, so I'm going to say it.
Right. Now, Senator Vera, I'm going to allow you for this particular clause to read it, but not after that. You will have a little time because the way you have proposed your amendments are much too wide and will not fit into the text of the bill. So we need you to be a little more specific.
Thank you.
And as you can see, we're taking a lot of amendments from the floor, and it'll become very difficult to manage.
Understood,
Okay?
Chair.
Thank you.
So I was just going to suggest that the respondent wear an electronic monitoring device.
Words inserted.
I would insert a new 10, and it would read that the respondent wear an electronic monitoring device. This comes in the wake of people stalking and hunting down
I
women.
understand, but may I respond before we go there, please? So I think it's novel. I think it's brilliant. Couple concerns jump out. Number one, we propose right now in the Electronic Monitoring Act, and we did those amendments, that an electronic monitoring bracelet can be put in the course of a domestic violence order. That's amended already. So that's part of the existing law. So that would apply as part of it. Unfortunately, I think the version of the acts that most people are reading from don't have the consolidated amendments that we captured most recently when we amended the Electronic Monitoring Act. So that's there already. So in that circumstance, I'm inviting Senator Vera to consider that we don't really need to do that position for electronic monitoring because it's already captured on that point.
Understood. I will withdraw that. On the other point, I was going to include mediation, but in light of what the chair has said, and also I'm getting mixed reviews. Now, I always believe that in a domestic violence situation, there's an opportunity for an intervention by a third party to heal a family in crisis. So I know that there's a situation where women have been hurt, they've been killed, but most times what you have is a situation where there's an opportunity to bring order. So I'm very much in favor of the professional counseling, and I was also going to suggest within the counseling the possibility of mediation, but I will leave it at that.
So, Madam Chair, if I could just quickly say, we're proposing the addition in the bill of the rules of the Supreme Court to make rules for the first time, and also for regulations. And it's specifically in the RSC approach that the Chief Justice's approach, as we know, the whole concept of mediation and the overriding objective across the several rules, criminal, civil, family, children, has taken that approach. So we intend for that to come alive in the subsidiary route, which is the rules of the Supreme Court additions.
So you withdraw? Thank you very much. Honorable Senators, the question is that Clause 6 be amended as follows at page 17. Clause C.A. to read as follows: by deleting before the word receive the word both and substituting the word child. Okay. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Honorable Senators, the question is that Clause 6 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 6 as amended now stands part of the bill.
Clause 7.
The question is that Clause 7 stand part of the bill. The question is that Clause 7 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 7 now stands part of the bill.
Clause 8.
The question is that Clause 8 stand part of the bill.
My concern was taken care of by the just amended Clause 6, which provides for the applicant to also get assessed and counseling. So I withdraw my proposed amendment.
So you withdraw? So, Honorable Senators, the question is that Clause 8 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 8 now stands part of the bill.
Clause 9.
The question. The question is that Clause 9 stand part of the bill. The question is that Clause 9 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clause 9 now stands part of the bill.
Clause 10.
The question is that Clause 10 stand part of the bill. Senator Vera.
Chair, I've run foul of your injunction by not putting the words, but basically what I was asking for here is The undertakings are a very important part of the domestic violence process. There are things, for example, where you have a bipolar person or someone who is not taking their medication, but you can't order them to take the medication. The court can't do that because the person has a right to refuse them to make an informed decision. But if the person were to make an undertaking that he would do that or participate in getting medical attention or counseling, that is certainly something I think a court should be mindful of in whether or not to grant a protection order.
Madam Chair, this was the subject of great concern by the stakeholders. And the rationale for the removal of the undertaking was far too many cases fell apart by an undertaking which just simply took the wicket out of the case. So the rationale taken from a policy perspective here was, and I just got some stakeholder submissions. For instance, Mrs. Sibran-Sweet is cautioning about battered women being compelled to reconcile, or in the submissions that I have, recognition of where the undertaking is used to frustrate the process of the domestic violence process itself. So it was for that reason that we removed the undertaking, and more particularly, we then moved towards making sure that the matter had to be dealt with. In other words, then come to a decision, use risk assessment, use mandatory reporting, have a database, etc. So it was in that reasoning that we caused the amendments that we did.
Just saying an undertaking to do.
The question was the compellability of the undertaking. So the undertaking came about in the it's as good as an order and enforceable as good as an order. So we had to treat with the mischief that the undertaking had caused over the last 21 years. There's nothing to stop you from giving an undertaking to the court. So I don't know that we're excluding ourselves out of that at all.
You see, I come back, I know that for a lot of the activists, the real concern is about the murders, the woundings, and so. But there are many, many situations where that is not the issue. It's an opportunity for healing. It's an opportunity for counseling. It's an opportunity for intervention. And this is where I think an undertaking is a reasonable thing. It can go towards making the family adjustments that are needed.
Honorable Attorney General, through you, Madam Chair, the thing is, the concept of the undertaking is something that both sides would have to agree on. So even if it is the respondent indicates through his attorney or on his own volition that he wants to give an undertaking and the applicant is not minded to entertain such a move by the respondent, the matter will proceed as per normal. So I'm not quite convinced then that there's need to remove it entirely as an opportunity. Just like Senator Vera said, some matters can end in an amicable way based upon the undertaking being given, and a familiar situation could be preserved because persons have an opportunity to speak, to cool down. And as the Attorney General indicated, it has found its way in a kind of crazy position where it is also enforceable.
Madam Chair, I believe that we have to be guided by the evidential facts. I think the Attorney General's guidance by the professionals who understand this, because while we're happy to talk about getting people involved in trying to fix the problem, it is easier said than done. So I would err on the side of making sure we follow the advice of the people who have been in this for 20 years. Otherwise, we could end up with more deaths on our hand, although we could have some solutions. But unless we don't have empirical data to support the change, it would make better sense to take the advice of the people who are involved in the day-to-day handling of these situations.
Richards.
Thank you. I'll be quick, Madam President. And to follow what the Attorney General has said through you, there's nothing that prohibits the parties from seeking some sort of counseling for reconciliation after the matter has been stabilized and the person protected.
Attorney General.
Madam Chair, thank you. the critical amendment that we made here is stopping an undertaking before the completion of the matter. So the data was, and I thank Senator Amar for putting it quite clearly, the data that came forward is, look, this practice of an undertaking before the ventilation of the issue didn't give the people with responsibility and protection powers the ability to see the four corners of the mischief. Because the minute you got into court, attorneys advised their client, look, boy, give an undertaking and let's get out of here. And that undertaking issued a protection order. That protection order didn't allow for the gravity of the situation to be known. So we changed before to after, saying if you want to give an undertaking, which is as good as a protective order, a protection order, it must be after evidence has been taken. That's where the risk assessment comes in. Do you get bail, etc.? So I'm quite certain that we're making the right move on this one.
I'm quite happy with the undertaking after. But what I'm saying is that there should still be the possibility, after you've heard all of the evidence, for the undertakings to be made and undertakings to do certain things, not just that I won't do this, but I will do X, Y, and Z in a way that will keep the harmonious relationship.
Very small point, Madam Chair. Honorable Attorney, what I'm trying to avoid, if we remove the ability to give the undertaking before, what I am almost, as I say, virtually certain is going to happen, you'll have people withdrawing the matters from the court. So you're not allowed to give the undertaking now, but you want to make back up. You want to go through this trial? No, I don't want to go through the trial. Well, then, all right, so we do have undertaking again, withdraw your matter. And then what you'll have happening is that you'll have applicants who really may be in dire straits coming to the court again to take out another protection order, and then the GPs or the clerks of the court may not be minded to treat with them because they may consider them to be vexatious in nature.
That's true, Madam Chair, in the old system. This government is not operating with that structure. Number one, we now have no longer clerks of the peace. We have registrars of the court at the magistrate, they're legally trained personnel. Number two, we have a gender violence protection unit. We have early intervention of the police. We have risk assessment going on. So we have changed the architecture that goes around this position in a much more significant way. When we're dealing with children, prior to this government, we didn't have children's advocates. We didn't have the children's authority attendants at court. We didn't have the children's court, which mandates that the children's court treats with child issues and has anonymization of records and positions, etc. So the ecosystem was dramatically different in those days. We have enough articulating pieces here to mitigate against the well-put risk. I accept, Senator Sobers, that what you say is genuinely intended, but we have a lot more architecture in place right now.
Vera?
Just saying, going back to the bipolar type situation, a court can't order a person to take medication. But if after the evidence has been heard, he says, I undertake to do this and that, it'll go a long way.
So, Senator Vera, what is your position with respect to your amendment?
It would be,
But there is no amendment to clause 9.
I had it somewhere. Oh.
Have no words for the amendment?
Accept an undertaking from the respondent that the respondent shall not engage in conduct or that he...
But Madam Chair, can I just caution? You see, we're dealing with the Domestic Violence Act. Yeah. On the criminal side of the equation, the undertaking relates to the offense. The offense is described as domestic violence, which is prescriptive as to not doing something which constitutes domestic violence. The positive undertaking that, look, I'll help myself, I'll take my medication, etc., those aren't the elements of an offense. So my problem is that I can't legislate in that direction.
I withdraw. I take the point.
Your proposed amendment to clause 10. So, Honourable Senators, the question is that clause 10 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 10 now stands part of the bill. Clause 11.
Madam Chair. I just wanted a little clarification from the Attorney General about Section 2, which deals with this issue of 21 days after the date of which the application is filed.
Are we on clause 11?
Yeah, yes we are.
Sure, just, sure, what is it that you asked?
There was a time period put in here for 21 days. I'm looking at this as a serious issue, and I'm just trying to come to terms with how we came up with 21 days. Where the court makes an order for substitute service under Section 12(1)(c), the clerk shall fix a date for the hearing of the application, which shall be no more than 21 days after the date on which the application is filed. Oh, well, maybe I'm on the wrong one.
No.
I apologize. It's on page 22, Attorney General.
I think that he was looking at Section 11 of the Act.
Yes, okay.
So we are on clause 11. Attorney General, you have an amendment.
Yes, Madam Chair.
Circulated. Yes.
So, Madam Chair, we propose at clause 11 that we amend at, well, we're going to delete and substitute just to make it easier. So we propose the deletion of B on page 20, and we insert instead, we substitute that an application referred to at 1 may be accompanied by evidence given on affidavit in the form 1A in the second schedule. B, it is not necessary to call a person who made an affidavit pursuant to 1A to give evidence unless a party to the proceedings or court so requires. And C in subsection 2, we're tidying up proceedings in a court of summary jurisdiction, and then we renumber. If I could explain what this is all about. Because the application comes forward and may be dismissed if you don't appear, we're insisting that the application may be supported by evidence. The usual form of evidence in a court is either by witness statement or by way of affidavit. What we're proposing is the form of affidavit here. This allows simply for the proceedings not to be automatically struck out for lack of evidence. It isn't that there is an obviation of the need to examine the evidence or to have a proper due process or fair trial position. It is simply to make sure that the application isn't struck out for lack of evidence when there may be a bona fide reason for it not having.
Honorable Senators, the question is that clause 11 be amended as circulated by the Attorney General. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is that clause 11 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 11 as amended now stands part of the bill.
Clauses 12 to 20.
The question is that clauses 12 to 20 now stand part of the bill. Senator Amar.
Attorney General, I'm just trying to get clarification on the methodology for the 21 days. I find it's kind of long, and I didn't understand it.
Amar.
It's on page 22.
Sure, it's clause 12. No
yeah,
problem.
clause 12.
Yes, clause 12, 2.
2.
May I? Yes, ma'am. So I thank the Honourable Senator for his question. The amendment that you're referring to must be read in the context of subsection 1. So 11 subsection 1 says, subject to 2, the clerk shall fix a date for hearing of the application, which shall be no more than 7 days after the date on which the application is filed. So step number 1, you can have an emergency application under section 19A. So you can get that immediately from the from the police station. B, you go to court, they must fix it for the application to be heard within 7 days. C, where you can't serve the application, the court has the opportunity to make substituted service. In other words, then, you can't physically serve the person, we're providing for substituted service. Because substituted service may be by registered mail or by way of advertisement in the press, the time frame is longer because it is the understanding that it may not come to the attention of the person in that time frame. Particularly because in the substituted service regime, let's say you advertise this application in the papers and the person never turns up. The fact of the advertising in the papers becomes notice to the person. And that notice to the person means you can enforce a protection order that is granted in the absence of the person. So it is the methodology by which we preserve the ability of the court to enforce its orders within the reasonableness of a time frame for service which is other than personal service.
In a sense, what we are hearing is that you file this action, the person doesn't get it, you put it in the newspaper 21 days after the newspaper.
Yes, so where the court makes an order for substituted service under 12(1)(c), the clerk shall fix a date for hearing of the application, which shall be no more than 21 days after the date on which the application is filed. So you file an application, you can't serve it because there's a process by which we say how you must do service. You jump to Section 12. Section 12 tells you how you do notice of proceedings. You go through the steps where the officer must try to serve. If he can't serve within 2 days, within 3 days, there's a whole regime. You get to the point where you hit a wall, you can't find the person, you make an application for substituted service, the court grants that. So the clock is running from the date of the application, not the date of the publication necessarily.
The question, Senator Mark.
Are we on clause 21?
No, we are on clauses 12 to 20. So, honorable senators, the question is that clauses 12 to 20 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 12 to 20 now stand part of the bill.
Clause 21.
The question is that clause 21 stand part of the bill. Attorney General, there is an amendment circulated by you.
Yes, Madam Chair. Madam Chair, we're proposing the insertion of the following subsections. Clause 21 amends Section 21 of the Act. Section 21 of the Act is the National Domestic Register. The old Section 21 used to be police powers of entry and arrest. We've cleaved it into two. We've created the register in Section 21, and then we've created a Section 21A to deal with police powers. In this Section 21, we're proposing to add to what are 4 subclauses. We're proposing to add the following: that the Commissioner of Police shall make reasonable security arrangements to protect the information contained in the register. Remember, it's a private register, against unauthorized access, collection, misuse, alteration, disclosure, or disposal. And C, any person who intentionally and without lawful excuse or justification reproduces, shares, or uses any information contained in the register, commits an offense, etc. These are replications of the sexual offenses registry, that sex offenders registry, as to the private part that we did to give some data security and privacy to make sure that there was no. In fact, I believe Senator Amin also raised it in her contribution of the need to protect the confidentiality of data.
Madam Chair, may I ask the Attorney General who are going to be placed in the register? And how long those persons who are going to be placed in the register be placed there? And what criteria will be used, I should say, to put these people in or on the register, as well as to remove them from the register?
Sure.
Are these things going to be contained in the regulations,
Yes.
Attorney General?
series of questions. I will let the Attorney General answer, and then Senator Choate wishes to raise something.
Sure. So, Madam Chair, just like fingerprints, just like photographs of the police are kept indefinitely under our laws, the domestic violence register is kept indefinitely. The criterion for entry are set out in the Act itself. In Section 21, you shall establish the register. It's the duty of a police officer responding to a domestic violence complaint to record a domestic violence report. You're making a report. All reports at the Trinidad and Tobago Police Service are kept indefinitely unless they are expunged by way of an application under Section 50 of the Police Service Act for the expunging of records or for certain positions. So we are keeping these things ad infinitum, just like we do photographs, all reports at a police station, etc. And we will, of course, have some further assistance by way of regulations, which can be produced under the amendments that we cause later on in the bill.
Okay, sir.
Thank you, Madam Chairman.
Oh, Madam Chair, forgive me. I was reading out Section 21, which is actually Clause 22, and I went perfectly in that error of referring to what is really Clause 22. So forgive me, I have no amendments to Clause 21 per se. I'm looking at Section 21. So my first column that says Clause 21, that really ought to be 22. So, and they both relate to 22.
Okay.
I apologize sincerely. And my discussion was properly as I refer to Section 21.
Senator Mark, you raised something about Clause 21. The Attorney General, Senator Choate, you wanted to raise something about Clause 21?
Yes, about Clause 21.
So this is inserting the part, heading, domestic violence register. That's all that 21 does. I think we're all on Section 21, which is Clause 22.
I see. Okay, so the subsection 5 and 6 has to do with 22?
Yes, it was my mistake.
Okay, well,
I apologize.
Madam Chairman, that's...
I have put is in respect of Clause 21. Okay? So Senator Mark, do you have a question on Clause 21?
Yeah, I just wanted to get clarification.
Sure.
Through you. Attorney General, there's only going to be one national domestic violence register for both men and women. You're not going to separate the register in terms of women, a register for women
Madam
who are
Chair,
victims?
I apologize. That's on Clause 22. Clause 21 is insert a heading, Part 6, National Domestic Violence Register. So all of these questions are really in relation to Section 20, Clause 22. So if I could answer that under Clause 22.
Okay, ma'am. You like...
Senator Vera, you are going to ask a question, please, on Clause 21.
E.
There is no 21E. No. 21,
That's 22.
page
That's 22.
30 of the bill. Am I right?
Yes,
Okay.
insert the heading, Madam Chair. So the question is that Clause 21 stand part
Honourable
of the bill.
Senators, I beg you. The question is that Clause 21 now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clause 21 now stands part of the bill.
Clause 22.
Clause 22. Honourable Senators, the question is that Clause 22 stand part of the bill. Attorney General, you have
Yes, ma'am.
amendments.
Yes, ma'am, and I apologize to honourable members. On the first page of my circulated amendments, when you see the number 21 on the left side, just change that to 22. You will see a number 22 just under that. Just incorporate that into the same 22. So there are two sets of amendments there. So we can do it as A and B. What is 22 on the bottom will really be 22A, capital A, if you could do that, Madam Chair, because it comes sequentially first. And what you have as the new 21 going to 22, just put a B next to that, because it's sequentially after. So with respect to 22A, in paragraph D, insert after the word all the words orders and. So that is subparagraph D. And I think that that is really straightforward, right? So it should be, the Commissioner of Police shall ensure that all orders and domestic violence reports are entered in the register. So we wanted to capture all things that come to the Commissioner of Police. The next thing that we do in 22B, which is the bigger box above, inserting after subsection 4 the following subsections 5 and 6, that the Commissioner of Police make reasonable security arrangements to preserve the confidentiality, and then we create an offense for people who intentionally disclose these things in circumstances that they ought not to. The rationale is to protect the privacy of the data, the security of the data from the law enforcement side, and to criminalize any intentional breach without lawful excuse. Those are the reasons for the amendments, Madam Chair.
Senator Choate.
Thank you. Honorable Attorney General, I was wondering whether in 22 subsection 5, instead of saying shall make reasonable security arrangements, perhaps we could make the bar a bit higher and say shall make all necessary security arrangements. I suggest this because there is no penalty if the Commissioner of Police really doesn't treat this as serious a matter as he should. And I'm not talking about any particular Commissioner of Police. It may be a Commissioner of Police 20 years from now, who knows. And with respect to 22 subsection 6, we're not covering everything because we are talking about reproducing, sharing, or using. But the person who extracts or collects the data is not penalized. So I'm respectfully suggesting that we should include words to cover that, the extraction or collection of data from the register.
Madam Chair, I would like to ask the Attorney General, is there a period before records are expunged, or they are going to be there permanently?
So in answer to the latter question, records are kept indefinitely, and the reason is, number one, there's no statutory period of limitation for crimes. You may in fact have a cold case, so that's the reason why you keep things there. If the question is whether they go historically beyond your death, yes, they do. Is there a mechanism to remove your records? Yes, there is. Under the Police Service Act, you can apply to have things expunged or removed from the records. So that's treated within the usual context of law. If I look to the structure of subsections 5 and 6, and I've just pulled up the DNA legislation, and I'm looking to the steps that we've put for the Commissioner of Police to manage that piece of law, and then, yeah, and if I go to the sexual offenses amendments that we did recently, if I could just pull that one up. So we use the same formula for the maintenance of the sexual offenses registry as we have done here. I'm just trying to pull up the law for you to assure you that the wording is exactly the same. Sexual Offences Amendment Bill 2019. Okay. Lower. Shall be a register to be known as the National Sex Offenders Registry. Register shall, etc. Information contained in the register shall form part, but such information shall not be accessible to the public. Subsection 5. The Commissioner of Police shall have control and custody of the register and shall be responsible for maintaining, ensuring, shall make, here we go, 6. The Commissioner of Police shall make reasonable security arrangements to protect the information contained in the register against unauthorized access, collection, misuse, alteration, disclosure, or disposal, which is the same wording we have at subsection 5. And then we have taken a subsection 6, which is a little bit lower down. And then we borrowed from 48 subsection 4 in the sex offenders law, if I could call it that, the amendments to the Sexual Offences Act. Any person who intentionally and without lawful excuse or justification reproduces, shares, or uses any information contained on the website referred to in subsection 1 commits an offense and is liable on summary conviction, etc. And just to let you know, I had borrowed that from the Privy Council website in their unauthorized utilization of positions. So that's where the precedenting of law came from.
Yes, thank you, Attorney General, but that still doesn't allay my fears, because it appears as though the subsection 5, which we are dealing with in the current legislation, which marries subsection 5 in the legislation which deals with the registry for sex offenders.
Yep.
That is preceded by another section which talks about the collection and storage and so on. And I think, if my memory serves me right, inbuilt into that section is the kind of protection that we would want to have for the data in this legislation.
I think you're right. Just give me one moment, okay?
Sure.
CPC, I think.
And with respect to the reproduction, sorry.
Just 1 second. Attorney General, you have the wording.
May I hear the balance so I could perhaps adopt the rest in one go?
Well, I am the one recording it. I just want to get, is it that you're accepting what Senator Choate initially said? Because I think she's moving on to another point.
Well, I thought they were tied in, Madam Chair, so I wanted to see to capture
Senator
the two
Choate, can
together.
I just have, is it that shall take all necessary? Is that what you were saying?
Necessary, although I think perhaps the Honorable Attorney General is maybe considering another option for it. I don't know, inclusion of a similar predecessor clause. I don't know. But I think we have a little gap here in subsection 6, because if we have a hacker taking this information, we are not making that person criminally liable under this law. We are simply saying that if he reproduces or shares it or uses it, then he is liable. But we also want to make sure that whoever extracts or collects the information is also, such a person is also liable, criminally liable.
Understood. Madam. So, Madam Chair, I accept Senator Choate's very wise submission that we ought to go a little bit further to ensure safety in this law. And if I may propose that we insert into the amendment as circulated a new subsection 5. We'll renumber 5 and 6 as 6 and 7. So if you'd permit me to dictate the suggestion for the new subsection 5. And I'm taking directly from the Sexual Offences Act as we amended it. The Commissioner of Police shall have control and custody of the register and shall be responsible for dash A as in apple, maintaining the register, semicolon. B, ensuring that information is entered into the register in accordance with this Act and any other written law semicolon, and C, ensuring that the information entered in the register is accurate, full stop. We would then renumber what appears on the circulated amendments as 5 as 6 and 6 as 7. With respect to Senator Choate's observation that we have not caught the person who actually gets it in the first place, but we're only getting the person who reproduces it, the difficulty we had there was the same difficulty we had in the cybercrime law, penalizing the person who gets it. And my red flag is the media. We didn't want to criminalize the media in particular for actually getting something which may have come to them. But instead, we wanted to capture the reproduction of it.
No, but I think a police officer who extracts it, or let's say an IT person on contract who extracts information from the registrant, who'd be doing so unlawfully, would go unpenalized.
You see,
Isn't that the bigger problem? You getting the information out of the register for some unlawful purpose?
So, but the real drama is the mischief in disseminating the information, as opposed to acquiring the information only. I accept that acquiring the information is an event which ought to be captured. The problem that we have had in all of our laws is the journalistic pushback in, I got it, somebody sent it to me, but I didn't reproduce it. Do I want to criminalize the media person who accepted that? Somebody dropped a flash drive and had the information there, but they didn't use it.
Well, then perhaps what you could say is extraction, because that would mean that it's somebody on a computer somewhere who is hacking into the Commissioner of Police's database and getting this information, and surely that must be wrong.
Let me borrow the copyright law now. A reproduction is any copy. So technically, the minute I copy or extract it, I'm guilty of reproduction.
Are we sure that that is the interpretation that's going to be put on the word reproduce in the context of this legislation?
To answer that, no, because I think it'll be open to the court to deal with it. The mischief that we wanted to capture, bearing in mind the arguments we had with cybercrime, etc., was the whole media issue.
So what is it? I still cannot understand this, through you, Madam Chairman, the difficulty with penalizing the extractor. That's to say, the hacker or the police officer who wants to get this information for some unlawful purpose. I think that is a clearly identifiable person who might be breaking the law.
So reproduces, shares, or uses any information is fairly broad.
Well, those are
secondary,
third party, second party, and so on. We want to get a man who is actually taking the information from the commissioner's database without the commissioner's permission.
So you're thinking the word obtains before reproduces?
Well, I think extraction would be a better word, simply because I understand your concerns about the media. So let's avoid that difficulty. And if we use the word obtains, we make it wider. But if we use the word extracts, then it is clear that we are talking about the person who is removing the data.
What's your view? Madam Chair, the CPC's department is suggesting that before the word reproduces, we could, and I'm asking for thought on this, please, consider extracts, alters, removes. Question is if we're going too wide. So without lawful excuse or justification, I think we should well, an altering is actually quite, how about if we were to say intentionally? Yeah, so we have intention there. Right, so we got intentionally. So yes, Madam Chair. So if we could say in subclause 7 as it's circulated, as renumbered, forgive me, if we were to say after the word justification and just before the word reproduces, insert the following words: extracts, comma, alters, comma, removes, comma.
Yeah.
And it has a sufficient justification, attached it to modify the animus. So I think that may capture it. Senator Choate, through you, Madam Chair.
That sounds reasonable.
Much obliged, ma'am. Thank you for your indulgence.
Madam Chair, just on a point of clarification, is this a greenfield database?
As opposed to a brownfield database? Meaning?
No, meaning a brand new startup from scratch.
Yes. There's never been a database.
So all the historical information goes to waste?
No. The CAPA, the Crime and Statistical Division of the police, there's an exercise of digitization of all data across whole of government right now. So there's nothing to stop us from treating with that, and then we backfill data. All records are historically intact. What has not been done prior to us now was the digitization of data. So we're doing that at the Registrar General, all over the place. So that historical data will not be on a register per se. It will only be go forward the act that the register is populated, because we can't introduce into the register for utilization under this act things which are in arrears.
So are you saying that the historical information will be installed in this database?
No, I'm saying the opposite. I'm saying that there may very well be two databases. One which would have prior to act being proclaimed information, and then another which is called the register, which is prospective.
And the police will use which one in their determination?
They would use all. One under the purview of the Act, the Domestic Violence Act, which would be categorized under the pot the register. And in terms of their tracing of people, all other information would come up.
And finally, would it be your intention to bring them together sometime in the future?
I would love to, yes.
The question is that clause 22 be amended as circulated by the Attorney General and further amended to read as follows. New subsection 5, the Commissioner of Police shall have control and custody of the register and shall be responsible for (a) maintaining the register, (b) ensuring that information is entered into the register in accordance with this act and any other written law, and (c) ensuring that the information entered into the register is accurate. At renumbered 7, by introducing the words after the word justification, the words extracts, comma, alters, comma, removes, comma. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Honorable Senators, the question is that Clause 22, as amended, now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 22, as amended, now stands part of the bill.
Clause 23.
The question is that Clause 23 stand part of the bill. So there are amendments circulated to Clause 23 by Senator Mark, Senator Thompson-Aye, and Senator Vera.
Madam Chair, excuse me. The Attorney General had the other part, 22A, paragraph D. Was that included? 22A in paragraph D, insert afterwards all orders and.
Yes.
On page 31.
Yes.
It was included?
Well, yes, because it was the clause 22 plus the amendments as circulated and further amended as I read out.
Okay.
Clause 23, Senator Mark.
Yes, Madam Chair, I have discerned two weaknesses. One, I have advanced in the context of a specific amendment, and that is reflected in the amendment that has been circulated to ensure that the police officer is aware of his duties at the material time when this situation occurs or he receives a report on domestic violence. So we want to have it clearly outlined in the legislation what the police officer will have to do. In addition, Madam President, I don't have it as an amendment, but for consideration. And that has to do with the consequences of failure on the part of the officer to respond. Is there going to be a consequence, Madam President? I think that is the concern I would like the Attorney General to address. But I'd like the Attorney General firstly to consider.
Sure, Senator Mark, Attorney General.
Thank you, Madam Chair. So, Madam Chair, we have in 21A, we've extracted out of the old 21 what is 21A, specifically so we could create the register and then create the mandatory obligation for the police officer to respond to every complaint or report alleging domestic violence. And we use the mandatory word shall.
Right.
The recommendation coming to us, so that is every complaint or report alleging domestic violence.
Right.
Senator Mark's recommendation is a police officer shall respond to every complaint or report alleging domestic violence, so we add idem on that. The proposal is that where a police officer has reasonable cause to believe that a person has engaged in or attempted threatened physical violence, the police must investigate and decide whether to arrest, charge, or refer to social services. This came up in our discussions with the Law Association. It's been echoed in this chamber in several pages of amendments offered. And I'll say now what I explained then, which was accepted, but they've now come back again. My fear is the Judicial Review Act and the abuse of the Judicial Review Act. There is a large body of JR applications in this country where you state that you should do X and Y, and then you go into whether it was reasonable for the officer not to do X or not to do Y, and then the state gets opened up into a massive amount of damages and costs and then withdrawn applications. And I made that point to the Law Association, and they agreed. They said that they recognize that our JR legislation probably needs to be addressed like they did in England. In England, they addressed the JR Act. When you add that to the section 14 of the Constitution rights, you get an even wider amplification of risk. So first of all, if a police officer has reasonable cause, he must do as is suggested in subsection 2, because we're putting a mandatory obligation that he must respond to every complaint or report. An officer would be acting in breach of the Police Service Regulations and the Police Service Act if he didn't take a step. So the language in subsection 2, albeit helpful, opens the JR door. And I'm very conscious about that before we get this law working right. I really don't want to have a runaway set of judicial reviews hitting us. And as the Attorney General now, I can testify to you that those are very expensive and time-consuming. So what we had intended to do was to take the prescriptive approach via the regulations and the rules of the Supreme Court. Now, there are regulations under the Domestic Violence Act, which we propose are added in. You'll see it at the end of the bill. And secondly, under the Police Service Regulations route, under the Police Service Act, there are regulations there. The Commissioner of Police is now building that out with the creation of the unit, with the creation of protocols, etc. So I'm genuinely requesting that we take care not to open this door too wide, because I have to look at the abuse of what can happen to the state as well. Now, the issue of risk assessment, that's absolutely germane and real. My submission to the Law Association, and this was echoed by Shireen Pollard, who attended the meeting for the TTPS and the judiciary representatives, etc., is that we would treat with the risk assessments by way of the subsidiary route, because we want an opportunity to develop it and to get it right. That's why we've introduced rules of the Supreme Court and regulations. So whilst I think that the recommendations are genuinely well intended, in the experience of managing the state's litigation, I'm very cautious about opening that door immediately. Not that it wouldn't happen as we get a little bit further. Look, we're now at the point where we're legislating the judge's rules in evidence. In our Special Select Committee on Evidence, we're now incorporating judges' rules and police rules effectively into law, because we've got it right at this point. So I'm asking for the opportunity to develop that in further form and fashion.
Senator Choate.
Thank you, Madam Chairman. Honorable Attorney General, I'm looking at clause 23 and your proposed 21A. Now, sorry?
With this, you're not dealing with Senator Mark's amendment. You're dealing with the clause.
With the Attorney General's.
The bill.
Yes.
The bill itself.
Yes.
Okay.
Is that okay?
Well, I have 4 sets of amendments to clause 23. So I'm kind of let's just deal with Senator Marks, and then Senator Choate, I will invite you to make your observation.
No problem.
Senator Marks?
Yeah. Simply put, Madam Chair, the provision or the clause in 23 is very limited, and we do not get any sense from the legislation that there are consequences to be followed if a police officer who should respond and did not do so, and a person is killed or a person is seriously harmed. What are the consequences in the legislation to address that situation? And that's why we propose, and I support the Law Association and the team, to specify in the law what the police officer has to do, must do, because there are consequences here.
Thank you, Madam Chair. And just for efficiency, I know you haven't proposed my amendment as yet, but it's basically along the same lines as Senator Mark has proposed. So I'm willing to withdraw that and comment at the right time and comment on Senator Mark's proposal, because it's basically the same thing in...
On Senator Mark's proposal now.
And I have the same concern as Senator Mark in this, because we are here after decades of needing to amend this law to protect lives and hold certain institutions responsible. And I really think, I agree with Senator Mark that there has to be some duty and responsibility afforded the officer. And I also have concerns about the way it's stated in the bill itself, that there's no obligation of a timeline involved and no consequence if this is not carried out effectively.
Madam Chair, I get where everybody's going, you know, but I have a different perspective. After 5 years of sitting as the Attorney General in this country, I can tell you the abuse to law is very real. So we're at the infancy stage, 21 years after the 1999 Act, in causing significant amendments. We've just birthed the new domestic violence units. We now have the ancillary divisions working. Imagine jumping right now to say you must do something within X time frame, and these are the factors that you want to go, and you must conduct a risk assessment, and we haven't defined what a risk assessment is in the law, and what is reasonable in those circumstances. Now enter the realm of judicial review. Case coming from John Brown saying, look, the TTPS, it was not reasonable for them to do this, and now we enter into the realm of judicial review on conduct of criminal matters. That's Pandora's box, honestly. And what I'm asking, at least for consideration, is I catch where honorable members want to go, which is why I want to refer honorable members to the fact that in clause 28, we're asking for regulations to be made, rules committee to have positions. Now, to answer Senator Mark's concern as to what is the consequence for a policeman failing to do this, that's where the Police Service Act and the Police Service regulations come in. But we have to be cautious about opening this door immediately to the concept of strict timelines and positions. We've already considered risk assessment a little bit later on when we get to bail applications, etc. And the police asked for the opportunity in our consultations to develop their risk assessment profile. So I accept that it is a very laudable objective, but I want to please ask honorable members to be careful about pushing at the door when we have not quite figured out whether the cement outside the door is dry yet or not.
Thank you, Madam Chairman. I appreciate the intent of the various proposed amendments dealing with this particular subsection, because I see that senators want to try to do two things. They want to try to ensure that the police act and that the perpetrator is caught and he faces a system of justice, and that the victim receives the kind of treatment from the system that she ought to. Now, I think when you refer, Honorable Attorney General, with all due respect, when you refer to judicial review as being the big problem, what lodges in people's heads is the idea that money is more important than life. And I am sure that that is not what you intend to say. I think perhaps we need to be reminded of a few things. One, a police officer investigating or taking a report in this case, and this is why I had respectfully asked to speak on it, because I think we could just toughen up a little bit what you have here with respect to recording and so on. Remind senators that there are consequences to be faced by a police officer who fails to do his duty, not only within the TTPS, but also at the Police Complaints Authority, which is an independent authority and has acted independently. In addition to which, so there is recourse for the person who is not getting the service from the police that he or she thinks that they might be entitled to. Now, we are not aware of the protocols which the police are going to be putting into place for the support of victims, but there is something in the legislation which says that such protocols will be put into place. So that, in my view, should allay some of our fears. I agree with you. I don't think we should legislate without knowing what risk assessment means. We might not agree with what the police decide is risk assessment, for example. So I think that I accept your point of view, that this is a little premature. Senator Mark's suggestion perhaps is a little premature at this time. But I do respectfully ask for the opportunity to speak a little further on about the strengthening of 21A.
Chair. Well, echoing the other senators, I think 21A, as you have here, is a step in the right direction. Like the other senators, I have been approached by the Law Association, and I think the concern is that notwithstanding the standing police orders, fact is there's under-policing, and it leaves victims in a state of feeling underserved and unsafe. So I think the proposal is really to guard against ineffective policing, to ensure responsive policing. What the recommendation, the amendment is, police are expected to investigate and to consider making a decision on whether or not to charge or arrest the alleged perpetrator. Now, you know in JR, and I think it's an important point, the court doesn't tell the person how to decide. So if the policeman makes a decision, I am not going to arrest or charge for these reasons, and he files a report, I think that would take care of the judicial review aspect. But I think the concern is you just don't show up, which 21A here says, I've responded, and that's the end of that. You must go further.
Quickly, Madam President, just following what Senator Vera has said, and I fully understand the issue of the judicial review and the backlog and that Pandora's box, but the other Pandora's box is the one that we're here to remedy, and that is this absent response or ineffective response could mean someone's life.
So, Madam Chair,
I want to wrap up on this, and I think Senator Mark wanted to say something, and then you'll respond, and I'll put Senator Mark's
I confess it's very hard to respond to so many views all at once.
No, it actually isn't. I'm keeping track of everything, so I'll remind you if anything.
I'm
Senator
so
Mark.
grateful, Madam Chair.
Madam Chair, I understand what is being said by all, but I'm not convinced at this time. I really believe that we have to button down and ensure that justice is served. And I do not want to leave this provision open-ended. And I'm seeing a repetition taking place in the future. It's like a white elephant, and 2 years from now, or a couple of months from now, we have a repetition of the same thing in the country. And that is why I am insisting on behalf of the bench, and that is the opposition, the Law Association. I support our amendment to have this thing established.
General.
You need to help me, Madam Chair.
Senator Mark is pursuing his amendment to the clause 23. Senator Choate seems to have accepted what you have put forward, and when the amendments are dealt with, she may make some suggestions with respect to clause 23. Senator Vera would like to see a strengthening of clause 23, and Senator Richards as well, while they're all accepting and understanding what you are saying about judicial review.
Wow. You are efficient, Madam Chair. Excellent.
Yeah.
Thank you so much, Madam Chair. Okay. So, Madam Chair, I think Senator Vera caught one aspect of JR, that is make a decision. The other aspect of JR is that your decision was so unreasonable that it is unlawful and it ought to be set aside. So, respectfully, you've caught one aspect of it, but the other aspect of it is equally difficult. Now, I'd like the opportunity to confirm that it isn't an issue of money in this position. Surely lives are by far more important than money. It wasn't intended in cautioning of the risk of judicial review and Section 14 claims under the Constitution that it is a matter of money. It's not that. It's the complication and killing the baby before it is born. And in that regard, I really do believe that Senator Choate quoted very, very well that this is premature. The risk of legislating that you must investigate and take a step, etc., doesn't end with a decision. The decision is now subject to review because it's a decision of a public authority. The state liability and proceedings then kicks in, and then we end up in no end of position on this position. The fact is that an investigation may take longer than one expects. One could allege, if we put in this formula, that it was unreasonable to not make a decision in a particular time frame, because now we have a statutory obligation that you must make a decision, and therefore inherent in that is that you must make a decision within a reasonable time. So are we going to create more complication out of that form of prescription right now? Perhaps I can address it this way. There are alternative remedies to action or inaction. Police Complaints Authority, police service regulations, the interdiction of the Commissioner of Police himself in terms of his management. But bear in mind that the Commissioner of Police is now birthing and has birthed a unit for the first time. And more importantly, for the first time in the history of Trinidad and Tobago, there is one electronic index of every report by time, by who made it, who the investigating officer is. Do you know that that's the one thing that has missed Trinidad and Tobago? If one were to ask the question, how many reports are converted to charges, charges converted to matters in the court that are ended in a particular time frame? We're only on charges and court. We didn't even catch the real issue, which is what happens to the report. And the classic tool of management is you cannot perform something that you can't measure. And this law, for the first time, creates something that no other law has done, which is to have an index and register of every single report. Understand the magnitude of that particular introduction. Now, respectfully, how do I, in the exuberance to get the law right, add on JR risk to that? No. I'm asking honorable senators to accept that it may be premature to accept the recommendations at this point for those reasons, Madam Chair.
So, honorable senators, the question is that clause 23 be amended as circulated by Senator Mark. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The amendment as circulated by Senator Mark is not accepted. Now, there are similar amendments circulated by Senators Thompson, I.E., Senator Vera, and Senator Richards. You withdrew yours, Senator Richards?
Yes, in light of the fact that it's practically the same thing.
Sure. Senator Thompson, I.E., and Senator Vera, are you pursuing your amendments, having heard what just transpired?
I certainly want to speak to my amendment because I think it is right that the police officer should inform the victim of...
Just 1 second, Senator Thompson. We won't deal with your amendment just yet. Senator Vera?
All right.
I just want a yes or no. Are you all pursuing the amendments, and we'll deal with them in the normal course?
I will not pursue the amendment.
You are pursuing it?
I will not pursue
You
the
will
amendment.
not. So, Senator Vera, you have withdrawn. Thank you very much. Senator Thompson, now you can proceed now with your...
My amendment is that, my proposal is that the police officer should be aware of what the rights are and give information. But that is not to say that he would not proceed and arrest and so on. This is an additional to the police doing his duty. And also the question of giving a report after he has completed his report, that giving a copy of that report to the applicant, to the victim or the survivor, whichever we wish to call that person. But it is important because there have been too many instances where the police have said they've acted on a report of domestic violence and the secondary victims have said nothing has been done. So that would obviate the situation. The person would have a report so that when whatever happens, that you can actually say, this is what the police did or this is what the police did not do.
Thank you, Madam Chair. The issue of the police acting or not acting is now going to be locked in by the fact that there's a record for everybody to see for the first time ever. My desire as Attorney General, certainly in the next Parliament, just after the election when we reform, will be to include an electronic register for every offense so that it can be tracked and measured and put in. So I accept Senator Thompson-Aye's observation that prior to this law, that really there's a he say, she say. The police say they did something and the victim says not. And we've all seen that dance, and certainly most respectfully, Senator Thompson-Aye in her many years of practice will know this much better than most people will. With respect to the recommendation at subparagraph 2 of 21A, a police officer at the scene of an incident of domestic violence or when the incident of domestic violence is reported shall inform the victim of his or her rights and give information on available support services. We had considered that these things would be part of the protocol of the officers assigned to domestic violence, because every station in Trinidad and Tobago has an arm of this gender protection and domestic violence and sexual offences units. They are now at every station. Any matter connected with domestic violence where a child is the perpetrator shall be referred to the Children's Court. That's the law right now. Under the Children's Act, you must spring to the children's attorney, the Solicitor General's Department. All child charge and child allegation matters under the Family and Children Division, as defined under that law, must go to the Children's Court. And more particularly, there's a protocol of anonymizing those records as well.
Precisely for that reason.
Sorry, I'm just dealing with what's circulated.
Yes, sorry.
So I'm dealing with your amendments as circulated. I didn't know you abandoned that or had a different
I should have
view.
been more explicit.
Madam Chair, subclause 3, a police officer responding to a complaint or report alleging domestic violence shall, as soon as practicable after completing the report, provide the person making the complaint with a copy of the report. Madam Chair, these are matters that we propose go into regulations and procedures. So I'm not quite sure if I've addressed all of the issues raised by the Honourable Senator. Forgive me if I've read just from the circulated amendments. I'm not sure if there's something further to address.
So are you accepting it? Is that what you're saying?
No, Madam Chair. I respectfully ask that we not take this step just yet. I think we may be slightly premature on it. I think because we haven't yet come to Clause 21 as it stands, I think maybe Senator Choate may have some observations there that could assist us, but I'm not sure what she's going to say yet.
So, Honourable Senators, the question is that Clause 23 be amended as circulated by Senator Thompson-Aye. Those in favour say aye. Those against say no. The noes have it. The amendment as circulated by Senator Thompson-Aye is not accepted. Senator Choate, you wanted to say something on the substantive Clause 23.
Yes, thank you, Madam Chairman. May I respectfully suggest that we reword 21A, Clause 23, which will be the new 21A. A police officer shall, and we can do a subsection 1, take a detailed report of every domestic violence complaint whether made by any person or by telephone. Now, I'm not a drafter, and I'm sure there's a much nicer way to say that, but essentially, we want to make sure that they take the reports, whether the report comes in by telephone, whether it comes in through a neighbor, or whether the victim goes to the station. B, the police officer shall provide the complainant with a copy of the report made. That allows the victim to see or to have confirmation that what she told the police has been accurately recorded. And it also gives her the opportunity to return and correct any error or omission made by the police officer. Not every domestic violence case ends in murder. So we have to consider that as well. It also empowers the victim in these circumstances who wants to pursue a case before the court to be able to produce that report to say that I had gone to the station on so-and-so night, and this is my report from that night. So evidentially, it helps her case. Then I think that what we also need to say is the police officer shall investigate each such report made. Now, the police officer might decide that, I investigate and there's nothing there. The police officer might decide, no, I think this woman needs to go to the hospital right away. The police officer might decide, I'm going to arrest this man right away for attempted murder or for murder. So you have certain mandates inbuilt into the section now, which I think would cover the victim, would cover the duties of the police officer. And I intended to say this at the beginning. Now, this is absolutely crucial because there was a domestic violence killing a few months ago, and the family and so on came forward and said, no, she went to the police station on so many occasions, and, reports were made and that kind of thing. And the response from the TTPS was, all we found were receipts saying information received. Well, because a police officer was lazy to write down the details of a domestic violence report, one, it may have been that because of that it was never investigated. The woman didn't receive the protection she ought to have received, and it ended in a death. So I think we need to sort of strengthen this section to ensure that that kind of excuse can never be used again. So I think the creation of the paper trail will serve us well.
Yeah. Madam Chair, I want to thank Senator Choate for what I think are excellent suggestions. I think that we can't allow the police to do the normal of come back tomorrow and I'll give you the report. I think in the case of domestic violence, that the instantaneous production of the report is an essential aspect. So if it's okay, we took notes. A little bit of surgery I think that we could do to the language just to capture the allegation of offense, etc. With your permission, Madam Chair, is it possible that I could ask CPC to draft that into some tighter form of language? Maybe we can press on with the other clauses and come back to this? Is that okay?
Clause 23 is...
Address the Honourable Minister on a very similar issue. many times victims or persons may report incidents of serious domestic violence occurring by a next door neighbor, for example. And when the police arrive, even though there is evidence that something is happening, the virtual complainant or the victim actually doesn't do or say anything. As a matter of fact, she protects the aggressor if it's in the case of a male being the aggressor. And that is something that the Evidence Act, the Domestic Violence Act, falls short of, and the police officers' hands are tied.
Could I just say something quickly? Okay. Remember, the Act says that a police officer can bring a domestic violence case on behalf of anybody. I think, unfortunately, police officers have been leery of doing so. In fact, when one of their number had been murdered in a domestic violence offense a couple of years ago, a young policewoman, no one had brought a complaint on her behalf. Police officers do go and get that kind of response from the terrified victim who has the beater standing right there. But I think the new training that hopefully they will get is to understand that evidence can come from the neighbor who saw. The evidence can come from the wounds on the victim's body when they take her for medical attention. It does not have to come from the mouth of the victim. So I think perhaps that should allay the fears of Senator Tranquil.
So we're going to stand down. Clause 23.
Clause 24.
The question is that clauses 24 and 25.
Yeah. Clauses 24 and 25.
The question is that clauses 24 and 25 stand part of the bill. The question is that clauses 24 and 25 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clauses 24 and 25 now stand part of the bill.
Clause 26.
The question is that clause 26 stand part of the bill. There are amendments circulated. Senator Mark, Senator Vera, Senator Richards. So let's deal with Senator Mark first.
Yes, Madam Chairman, this is a very simple amendment that is being proposed to ensure that in the event the person who wishes to make a report because of domestic violence, they can have some options available to them. So rather than only going, or rather than going only to the police, it is being suggested that these reports can also be channeled to the Division of the Family Services as well as the Children's Authority. And you know, Madam Chair, it reminds me of the time in the past when you live in a particular district and an incident takes place outside of that district, and they tell you, police that is, years ago, you had to go to your district to report. You could report your situation to any other police station. That has changed, however. And I'm saying that we don't have to wait until something happens to a person as outlined in this section or clause of the bill for action to be taken. So if the police is not available, they can go to the two areas, organizations that have been outlined. So it's a very simple amendment to give those victims options in the event of domestic violence and their inability to get to a police officer to report same. So this is the amendment that is being proposed for the Honorable Attorney General's consideration.
May I point out that the amendment that is proposed by Senator Mark is very similar to that proposed by Senator Richards and to Senator Vera. So, Attorney General, I suspect when you answer, you'll be answering to all. Attorney General.
Thank you, Madam Chair. These come from the Law Association, Equal Opportunities Commission, and the Coalition. They are what I call the Roberta Clark amendments. She's the author of these amendments. We've discussed them on many an occasion, and I've just received a text message from her asking me what my view is on it, as she pays attention from abroad. Yes, sir. Anyway, these are the pioneers, and I congratulate them for paying attention to an area like this, and I'm genuinely warmed that we have such excellent people who are committed to the service of Trinidad and Tobago. So I salute all these honorable people. It isn't that I didn't consider it. We discussed this at the 2 Zoom meetings in particular at great length. And if I could explain why we had left this issue the way the bill has it now. Madam Chair, putting a trident approach, police, Division of Family Services, and Children's Authority is what is on deck here right now. Alternate methods of recommendation. The difficulty that I have, the Children's Authority is easy. They're actually caught up right now. First port of call, TTPS. TTPS must alert Duty Council, Children's Attorney. Children's Authority is called immediately. Secondly, reports to the Children's Authority under the Children's Act are reported back to the TTPS in any event. So that route is easy, and that's part of the existing law as it is. The Family Services Division, however, is where I get into difficulty. Right now, there is not an organized structure at that division. And the minute we start referring people to 3 different locations, the congruity of approach and records falls into difficulty. What we're trying to do is to harmonize an approach right now. We have already passed in relation to children. No police car can turn up to investigate a child. They must be the subject of plainclothes officers, gender management, female to female, etc. And there's strict protocols in that. We've adopted the UN protocols in that regard. My fear, and I had asked the Law Association to consider this carefully, is that stepping too broad now when the mischief we have, look at the Children's Authority's report. The Children's Authority has an annual report every year that tells us of thousands of cases of abuse. Where has that gone? They report it. It's part of the structure. They tell the Parliament about it, but they don't get the buy-in from the TTPS because there's a distribution outside of the TTPS. So I had asked the stakeholders to allow us to harmonize the approach in the first instance. When we get that protocol right, we build the protocol at the other areas because we need to have consistency of approach in this issue. If you have a consistency of approach, you're going to get a result out of it. And that's the simple reason as to why we didn't take on board that amendment at this time. I think it's laudable, but the system is not organized well enough from a protocol and resourcing perspective. Remember, this Parliament, this 11th Republican Parliament has taught me how many laws have been passed that were excellent laws that went nowhere. Plea bargaining, 0. Sex offenders registry, 0. DNA, 0. Electronic monitoring, 0. Data Protection Act, 0. Land Title Act, 0. Hundreds of laws passed that went nowhere because they lack plant and machinery, people, processes in tandem with law. So I respectfully ask for the opportunity to get this law funneled and organized and then to take a step again when we need to. And I have kept my word as Attorney General time and time again. I've come back to the Parliament, Amendment number 1, Amendment number 2, Amendment number 3, as we get it right. So I respectfully don't agree that the amendments are necessary at this point for the reasons volunteered, Madam Chair.
Did you ask the stakeholders why they wanted to be different from what is done under the Sexual Offences Act, where reports are made to the police? Why did they want to change from that? Did they give you a reason?
May I? The answer that I got was that people may be less intimidated in an alternative forum.
Or is it that the professionals find they don't want to go to court?
Well, you see, the problem is that you may be less intimidated in an alternative forum, but that data shows, if you look at the Children's Authority alone, it shows that we're not going as far as we ought to. We've tried that. The Children's Authority report is here every year. We see it. Thousands of allegations coming at us, and we're not funneling and managing by system processes. I believe if you want results, you have to measure it and perform it.
And I spoke to that, my view on that this morning. I think it should remain with the police.
Thank you, Chair. Honorable AG, I understand what you're saying, and I think we're moving forward. In the old days, you had to report this situation at the neighborhood police station. We've moved from that. Now you could report it to any police officer, any station, anywhere. Great. And in the same vein, people who are victims should have as many options as possible, it seems to me. There are many reasons why a person might not want to go to the police. It might be inconvenient. They may have had bad run-ins with the police before. They may be an illegal immigrant. They may speak a different language. They may be, as you have said, be intimidated by the police and mistrust the police. So even if it's just the Children's Authority or some other authority, I think it behoves us to consider the wider options.
But look at this, protecting lives. Who's going to get the emergency application done at the Children's Authority? Who's going to get the emergency application done at the Family Services Division? You got there late at night, they have to go to the police. The law says that the emergency application under Section 19A is to be done this way. Why create two steps when you can go directly to source? You see, my problem is that the more we nuance this thing without getting to the heart of relief, and the heart takes some steps, right? I'm not saying this is the perfect law and we are the architect of the perfect piece of legislation. Far be that from the position I'm advocating now. What I'm saying is, we need to harmonize this approach. We don't have the resources of emergency application and police powers. Police powers are what save lives. And that respectfully does not exist in the Children's Authority and the Family Services Division. Not at present.
Senator
Focus.
Richards.
Thank you, Madam Chair. Through you, Attorney General, while I hear what you're saying, there's another way to look at this, such that while you say that your suggestion, if I understand it correctly, is that the Children's Authority is already overburdened and stretched to its limit and has received so many reports which are tabled in Parliament, etc. The multiple reporting opportunity here may just be able to serve as a cross-reference for the Children's Authority and the police in terms of different sources of information coming into them to see which cases to prioritize. So it may actually work to the advantage of the Children's Authority.
Look at what we're suggesting. The Law Association's suggestion, which several senators have echoed here today, is don't go to the police alone, go to the Family Services Division, and go to the Children's Authority. What I'm saying is that that dilutes the potency of the law that we're dealing with right now at this point in time.
I do think that's not my interpretation of it, is that don't go to. There are options available in addition to.
I know, but if you go to the Children's Authority as a point to report domestic violence, then you're not going to the police. If you go to the Family Services Division, you're not going to the police. If there's a police matter to happen, they need to go to the police. So what you're asking me to do is to facilitate alternative routes which are one step behind the primary route. And if I want to save lives, I need to go to the police, especially when we're saying that the police have created a specialty unit and there's a harmonization database on the spot. Senator Cho's recommendations, which we'll get to in a second, tell us, take the report, give the person a report, investigate the steps. I genuinely think that we need to take a phased approach to this, harmonize it, and then replicate resources after.
And as you're speaking, AG, there's nothing stopping a person going to the family division or to the Children's Authority in any event.
Correct.
And they can refer to the police.
Yes.
So, yes, I
The question is that clause 26 be amended as circulated by Senator Mark. Those in favor say aye. Those against say no.
Respect.
I think the noes have it. Senator Mark's amendment is not accepted. Senators Richards and Vera.
In that case, mine is
to
withdrawn.
pursue yours?
No.
Withdrawn? Thank you very much. Honourable Senators, the question is that clause 26 now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clause 26 now stands part of the bill. No.
Clause 27.
The question is that clause 27 stand part of the bill. Attorney General, there is an amendment circulated on your behalf.
Oh, Madam Chair, we just propose in 27 to just tidy up paragraph B, just inserting after the word police the word officer, just to make sense of the law.
The question is that clause 27 be amended as circulated by the Attorney General. Those in favor say aye. Those against say no.
It seems that we skipped over my clause amendment to 26. We took everyone else's except mine. I sincerely apologize,
All right,
Madam
let's
Chair.
just finish off clause 27. Honourable Senators, the question is that clause 27 be amended as circulated by the Attorney General. Those in favour say aye. Those against say no. I think the ayes have it. Honourable Senators, the question is that clause 27 as amended now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clause 27 as amended now stands part of the bill.
Clause 26 revisited.
Honourable Senators, the question is that clause 26 be amended as circulated by the Attorney General. Attorney General.
Madam Chair, we wanted to capture the fact that you would have a medical practitioner who attended to or examined. So we want to add in the words attended to because it's wider than just examined. And for those reasons, we ask that clause 26 be amended as circulated.
Honourable Senators, the question is that clause 26 be amended as circulated by the Attorney General. Those in favour say aye. Those against say no. I think the ayes have it. Honourable Senators, the question is that clause 26 as amended now stand part of the bill. Those in favour say aye. Those against say no. Clause 26 as amended now stand part of the bill.
Clause 28.
The question is that clause 28 stand part of the bill. Senator Mark, you have an amendment?
Yes, of course, Madam Chairman. Yeah, Madam Chair, I would like to suggest or propose that wherever you find in clause 28 the word negative, I'd like you to substitute for the word affirmative. And I did not include it as an amendment, but I would like to propose the following amendment to 33. I want to delete the Chief Justice. I don't think the Chief Justice has any business in our lawmaking process. I would like to put the Attorney General, the Minister, may by order, subject to a negative resolution of the Parliament, amend Forms 1 and to 6 in the second schedule. I've been in Parliament for several years. Yes. I've been in Parliament for several years, and I've never seen a Chief Justice. I know that he makes rules, the Rules Committee. He can take charge of his court, but he cannot take charge of the Parliament. These are things of dangerous development.
Thank you, Madam Chair. Madam Chair, affirmative resolution is a very cumbersome process for matters that can be dealt with by way of parliamentary scrutiny or subsidiary legislation in general. For those reasons, and for the many times that I have resisted Senator Mark's observations as to the need for affirmative resolution, I beg to differ and disagree with my learned colleague. With respect to the allegation that the Chief Justice can't cause an amendment, Madam Chair, that's just not the case. The rules of the Supreme Court are subsidiary legislation in effect, because the rulemaking power under the Supreme Court of Judicature Act, which allows the rules of the Supreme Court to be promulgated, are done under the hand of the Chief Justice. But more than that, Madam Chair, when you look at the second schedule, the forms, the application for domestic violence, Form 1, the affidavit in support of the application, Form 1A, the notice of failure to effect service of process, Form 1B, etc. These are quite properly matters that the Chief Justice really ought to have scrutiny over, because it gives us the flexibility of moving the law along as practice develops. So I respectfully wish to put onto the record that there is nothing odious about the Chief Justice causing an amendment to forms, particularly when those forms are court process forms, Madam Chair.
Madam Chair, these forms must be subject to our review, not the Chief Justice review. And I am insisting that my amendment be put to this House, that the Minister...
Well, Senator Mark, no need to insist. Okay. I'm going to put the amendments now. So, Honourable Senators, the question is that Clause 28 be amended as circulated by Senator Mark, and further amended as follows at 33(1) to delete Chief Justice and substitute Minister, and then after the word order include the words subject to negative resolution. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The amendment as proposed by Senator Mark has not been accepted. Attorney General, there's an amendment proposed by you.
Yes, Madam Chair. Madam Chair, we propose that Clause 28 be amended to allow for the ability to amend the first and third schedules by way of order subject to negative resolution of the Parliament. This would allow the law to continue to evolve in a flexible but yet careful process of parliamentary scrutiny, as the negative resolution will allow for the negativing of any positions come. The first schedule deals with the offences pursuant to Section 3, which are included into the legislation. You will see there the Summary Offences Act, the Malicious Damage Act, the Offences Against the Persons Act. The third schedule, Madam Chair, treats with the inclusion of offences against the person, sexual offences, Children's Act, and we propose trafficking in persons, which you'll see a little bit later on. That springs off of Section 20A3. The reason why we propose this is that if we don't allow for the ability to amend these, we're going to have to move an Act of Parliament each time we want to amend the schedule, when in particular we amend laws with such rapidity, particularly under this government's tenure, as you will notice, where in one miscellaneous provisions bill we may amend 60 laws. It is just to allow us the flexibility to move. We keep the caution of having the ability to negative by way of negative resolution.
Senators, the question is that clause 28 be amended as circulated by the Attorney General. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is that clause 28 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 28 as amended now stands part of the bill.
Clauses 29 and 30.
The question is that clauses 29 and 30 stand part of the bill. The question is that clauses 29 and 30 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 29 and 30 now stand part of the bill.
Clause 31.
The question is that clause 31 stand part of the bill. Attorney General, there is an amendment circulated by you.
Yes, Madam Chair. Madam Chair, clause 31 we propose ought to be it ought to be amended to allow for an amplification of the third schedule. The third schedule is important. These are the offenses where we spring, Madam Chair. If you look at the third schedule, we're springboarding off of section 20A3. Section 20A3 of the Parent Act. 20A3 is where we define a serious criminal offense. So in the new 20A, which we're inserting, we say, notwithstanding the fact that a protection order expires after a particular period of time, where there's a serious criminal offense, that protection order should continue to prevail. If we tie it to the existing third schedule, respectfully, we have not gone far enough, particularly because when we looked at our amendments to the Sexual Offences Act and we caused the population of a sex offenders registry, we agreed in a special select committee that it would be prudent to include the Trafficking in Persons Act sections where we were dealing with trafficking involving sexual matters, and in particular, trafficking in children. Those very odious offenses, in our respectful view, ought to be considered as serious offenses within the construct of Section 20A3. Those are the reasons for the proposed amendments to Section 31, Clause 31.
Honourable Senators, the question is that Clause 31 be amended as circulated by the Attorney General. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The question is that Clause 31 as amended now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 31 as amended now stands part of the bill.
Clause 23 visited.
The question is that Clause 23 stand part of the bill. Attorney General, do you have the wording of the amendment?
Yes, Madam Chair. May I read it quickly and then for the purposes of recording so that people catch it in its cadence? It's proposed that we amend it as follows. Subsection, so it will be 21A as in alpha, subsection 1. A police officer shall, A, respond to every complaint or report alleging domestic violence. B, make a detailed record of every complaint or report alleging domestic violence made in person or by electronic means. And C, provide the person making the complaint or report with a copy of the record. Subsection 2, a police officer shall investigate every complaint or report alleging domestic violence. I hope I've captured what Senator Choate had suggested. Yes? May I then dictate it slowly? So, Madam Chair, 21A as in alpha, subsection 1. A police officer shall dash A, respond to every complaint or report alleging domestic violence, semicolon. B, make a detailed record of every complaint or report alleging domestic violence made in person or by electronic means, semicolon, and C, provide the person making the complaint or report with a copy of the record. Subsection 2. A police officer shall investigate every complaint or report alleging domestic violence. Yes, Madam Chair. So effectively, our amendment is, as done. Yes, ma'am.
So, yeah. So, Honourable Senators, the question is that clause 23 be amended as follows, that 21A be deleted and the following be substituted. 21A1, a police officer shall -A, respond to every complaint or report alleging domestic violence. B, make a detailed record of every complaint or report alleging domestic violence made in person or by electronic means, semicolon. And C, provide the person making the complaint or report with a copy of the record. 2, a police officer shall investigate every complaint or report alleging domestic violence. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is that clause 23 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 23 as amended now stands part of the bill.
New clause 19A.
The question is that new clause 19A be read a second time. Attorney General.
Madam Chair, in scrubbing the Parent Act, we came across Section 20. Section 20 is breach of orders, and Section 20 is archaic. Effectively, if you contravene an order or fail to comply with any direction of the court, you commit an offense and you're liable, the existing law says, on first conviction to a fine not exceeding a whole $9,000 and imprisonment for a period not exceeding 3 months. 2, on second conviction to a fine not exceeding $15,000 or imprisonment for a period not exceeding 24 months or both. And 3, on any subsequent conviction to a period of imprisonment not exceeding 5 years. So the first fact is that that phrase not exceeding is now in odium in the courts, and we ought not to have that. The court has its discretion to consider. What we propose in the amendments to Section 20 are that we raise the fines and penalties. On first conviction, we go to $50,000 and imprisonment for 1 year. In the second instance, you go to $150,000 and imprisonment for 3 years. And on third conviction, we go to a fine of $250,000 and imprisonment for 5 years. And of course, the rest of it is just that we delete the not exceeding as words. They are offensive in modern drafting terms. We believe that this would bring the penalties in line with where we are in the modern context of laws, and those are the reasons for the proposed amendments.
So, Honorable Senators, the question is that new clause 19A be read a second time. Those in favor say aye. Those against say no. I think the ayes have it. New clause 19A will now be read a second time. The question is that new clause 19A be added to the bill. Those in favor say aye. Those against say no. I think the ayes have it. New clause 19A now stands part of the bill. Just pointing out that there may be a consequential amendment to 19A because in the bill you already have a 19E. So that is just.
So, Madam Chair, in my bill as printed, I see a 19 and a 20 as a clause. Now, there is a new section 19E that we're inserting. No, sorry, that's 20E. Yeah, we have a clause 19 puts in a section 19E. So this is new clause 19E. So I think we're in order.
New clause 23E.
The question is that new clause 23A be read a second time. Those in favor say aye. Those against say no. I think the ayes have it. New clause 23A will now be read a second time. Attorney General.
New clause 23E.
Attorney General.
Madam Chair, we propose the issuance of a warrant as it's casted in the current law says just a magistrate shall issue a warrant. With the Family and Children Division and the merger of jurisdictions and the fact that you may be in the High Court or before a master, we preferred instead to have the word court so that you'd capture all of the species of judicial officers that can issue a warrant. That's the rationale for this, to make sure that we have flexibility across jurisdictions.
The question is that new clause 23A be added to the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. New clause 23A now stands part of the bill.
New clause 28E.
The question is that new clause 28A be read a second time. Those in favor say aye. Aye. Those against say no. I think the ayes have it. New clause 28A will now be read a second time.
New clause 28A.
Senator Mark, this is your amendment.
Yes. Madam Chair, I honestly believe it was a genuine oversight on the part of the Attorney General, because I know he's a person who is a tickler for accountability. And with the kind of powers and the major reforms being attached to this effort, the Parliament would need to get some kind of reporting mechanism so that we can have sight and access on an annual basis to what is taking place with this very important piece of legislation that we are dealing with. So I have to admit that the Attorney General this one might have slipped him. So I have sought to help him address a very important lacuna in the legislation. And in those circumstances, I'm asking the Honorable Attorney General to give this amendment his undivided attention and consideration. I don't think I need to elaborate on it, just to say, Madam President, that a report ought to visit this Parliament on an annual basis so that we can have sight of what is taking place with domestic violence in TNT. We don't want names of individuals, Madam. It cannot be names. It is a report dealing with statistics, region, wherever it's taking place, so we will know what is taking place on that front.
General.
Madam Chair, I thank Senator Mark for raising an important issue of accountability and oversight, which obviously any parliament would want to enjoy for the benefit of its citizens. We did it in the sexual offences amendments that we did, but we said that the minister shall report on the operations of the Act. The difficulty that I have here is that we're talking about the register, and the register is a register of allegations, not necessarily convictions. So whilst I catch and I thank Senator Mark for the recommendation, I think that to carve it out on the operations of the register may be a little bit difficult. Perhaps when we get a little more experience, we can come back and find a way to capture the overall intent of oversight.
In other words, I take your point. So, in other words, let us deal with the Act so that we'll get a report on the operations of the Act. I think that would be a little better. We could carve it in that way.
Madam Chair, I think that that is a commendable suggestion. If I borrow from what we did at the Sexual Offences Amendment Bill, Act, we had, and I don't know if Senator Mark will take this on, we had put in the following language: the minister shall cause to be laid in both houses of Parliament annually a report on the administration of this Act. I think that one of our subcommittees would do very, very well to have this Act before them so that Parliament wouldn't have another 21 years before an Attorney General like me turned around to have a little serious stab at the law. I mean that in the best way possible. I don't mean it in any egotistical way. Sure, Madam Chair. So if it could perhaps read, the minister shall cause to be laid in both houses of Parliament, comma, annually, comma, a report on the administration of this Act. Thanks, Senator Mark, for raising the issue.
The question is that new clause 28A be amended to read as follows. The question is that new clause A, as circulated by Senator Mark, be further amended as follows: to delete 28A 1 and 2 and substitute the following words: the minister shall cause to be laid in both houses of Parliament annually a report on the administration of this Act. What should the marginal note read?
It'll say annual report. No, ma'am.
So shall I repeat it? The question is that new clause 28A, as circulated by Senator Mark, be amended as follows by deleting paragraphs 1 and 2 and substituting the following: the minister shall cause to be laid in both houses of Parliament annually a report on the administration of this Act. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is that new clause 28A as amended be added to the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. New clause 28A now stands part of the bill.
As amended, be reported.
The question is that the bill as amended be now reported to the Senate. Those in favor say aye. Those against say no. I think the ayes have it. The bill as amended will now be reported to the Senate. Attorney General.
Madam President, I wish to report that the Domestic Violence Act Amendment Bill 2020 was considered in Committee of the Whole and approved with amendments. I now beg to move that the Senate agree with the committee's report.
Honourable Senators, the question is that this Senate agree with the committee's report on a bill entitled the Domestic Violence Amendment Bill 2020 to provide for emergency protection orders and for related matters. Those in favor say aye. Those against say no. I think the ayes have it. Attorney General.
Madam President, I beg to move that a bill entitled An Act to Amend the Domestic Violence Act, Chapter 4556, to provide for emergency protection orders and for related matters be read a third time and passed.
Honourable Senators, the question is that a bill entitled An Act to Amend the Domestic Violence Act, Chapter 4556, to provide for emergency protection orders and for related matters be now read a third time and passed. Those in favour say aye. Those against say no. I think the ayes have it. We just to come into the chamber, please.
Mr. Khan?
Yes.
Mrs. Gopiskun?
Yes.
Mrs. Batiste Primus,
Yes.
Mr. Rambarat,
Yes.
Mr. Sinanan,
Yes.
Mr. Moses,
Yes.
Mr. Hussain,
Yes.
Ms. West,
Yes.
Ms. Cox,
Yes.
Mr. De Freitas,
Yes.
Mr. Singh,
Yes.
Mr. Cummings,
Yes.
Dr. Henry,
Yes.
Mr. Duque,
Yes.
Mr. Mark,
Yes. Yes.
Ms. Haynes,
Yes.
Mr. Amin,
Yes.
Mr. Sobers,
Yes. Yeah, man.
Mr. Transcosco,
Yes.
Mr. Amar,
Yes.
Mr. Richards,
Yes.
Ms. Choate SC,
Yes.
Mr. Vera,
Yes.
Dr. Dial Singh,
Yes.
Ms. Janarayan,
Yes.
Ms. C. Prasad,
Yes.
Mr. Timal,
Yes.
Mrs. Thompson Aye,
Yes.
Dr. Dylan Remy,
Yes.
Madam President, the result of the decision are as follows. 29 senators voted for, 0 senators voted against, and no abstentions.
Honorable Senators, the result of the division is as follows. 29 senators voted yes, no one voted no, and no one abstained.
A bill entitled An Act to Amend the Domestic Violence Act, Chapter 4556, to provide for emergency protection orders and for related matters.
Government business.
Madam President, I beg to move that the Senate do now adjourn to Tuesday, June 23rd, that's tomorrow, 2020, at 1:30 p.m., Private Members' Day. I've been advised by the leader of the opposition bench that we'll be dealing motion number 4 with regards to the Marilisa farm.
Honorable Senators, before I put the question on the adjournment, leave has been granted for 2 matters to be raised. Senator Mark.
Thank you very much, Madam President. Madam President, the first matter I'd like to raise at this moment deals with the need for the government to explain the system used to identify deserving individuals and families for receipt of state-sponsored hampers during this COVID-19 period. Now, Madam President, based on research conducted thus far, we have discovered a very unusual situation as it relates to the distribution of hampers in particular. Madam President, the classic definition of corruption is simply using one's public office for public gain. And
there is also, Madam President, a term which is known as the abuse of office. And what the material information has revealed thus far is that the government has been distributing hampers in particular throughout the country at taxpayers' expense. But, Madam President, what is very clear from an editorial in the Guardian newspaper of last week, Thursday, I believe, or Friday, was an article entitled Answers on Use of State Resources. And this particular Guardian editorial pointed out the unusual and unequal delivery of hampers to the various parts of the country. Madam President, what is very, very clear from the material that we have before us is that the People's National Movement, based on two lists, one dated May the 15th and one dated June the 5th, reveal severe inequalities in the distribution of state-sponsored COVID-19 relief hampers between the United National Congress and the People's National Movement operatives. Mr. Vice President, would you believe that the PNM, in their inequitable distribution of hampers at the expense of taxpayers' dollars, have engaged in the following? Mr. Vice President, in the constituency of Separia, they have distributed 50 hampers. And Mr. Vice President, as you go on to places like Pointe-à-Pierre, Princestown, Comuto, Manzanilla, 50 hampers. And this goes on. And Mr. Vice President, this is occurring at a time when taxpayers' dollars are involved. It is not PNM monies. It is taxpayers' monies. So you know what they are doing, Mr. Vice President? They are going into UNC constituencies, distributing and giving out 50 hampers to the respective members of Parliament. But here, what is taking place in the constituencies of the PNM? San Fernando West, 100 hampers. And Mr. Vice President, I want to tell you this evening, we have the evidence here in writing. We have the evidence of what is taking place. They have distributed 100 hampers to San Fernando West. They have, at the same time, Mr. Vice President, given 50 hampers to Naparima. But you know, when it came, Mr. Vice President, to Diego Martin West, and all the Diego Martin seats, is 150 hampers for Diego Martin West, 150 hampers for Diego Martin East, 150 hampers for Diego Martin Central. But, Mr. Vice President, what is going on is that when it comes to operatives of the PNM, in our constituency, like Naparima, they give our MPs 50, and they give their operators, who are called shadow members of Parliament, also 50 hampers to distribute. But when they come to the UNC constituency, Mr. Vice President, nothing for the UNC, whilst 150 hampers are given to the PNM Diego Martin West constituency. Mr. Vice President, this is a complete abuse of office by the PNM. And we cannot sit idly by and allow the PNM to distribute the taxpayers' dollars at this rate. It is too blatant. Mr. Vice President, we serve notice on the People's National Movement and the government of Trinidad and Tobago that we intend to take legal action. We intend to write all the relevant organizations like the police and the fraud squad that dealing with this matter. Mr. Vice President, the PNM must account for this blatant misuse and abuse of office. The PNM must be able to tell this country why are they using taxpayers' money in such an inequitable way. Mr. Vice President, who can be against poor people being given hampers? We want poor people to have access to food. But, Mr. Vice President, you cannot go in Diego Martin West. You cannot go in San Fernando West. You cannot go in San Fernando East and in all the other areas under the PNM control and give out 100 to 150 hampers. But when you come to the UNC controlled constituencies, you're giving only 50 hampers. Mr. Vice President, that is wrong. And this is why today we have taken the opportunity to raise this matter about the inequity, the inequitable distribution of resources under the cover of COVID-19 hamper distribution. And we saw it, Mr. Vice President, in a list that we have a copy of, dated May the 5th. And we have another list dated June the 5th. And that is what they have been doing. So I call on the Minister of Agriculture, in particular, to give an account to this Parliament as to what is the policy in place for the distribution of hampers. And can the Minister tell this Honorable Senate this evening, Mr. Vice President, whether the government has been engaging in the distribution of hampers in this inequitable way? Because we have all the evidence before us this evening. And I await the Minister's response to this matter because the people are very, very angry at what this government is doing with our taxpayers' dollars. Mr. Vice President, I pause and I await a response from the PNM government on the blatant abuse of office and the corruption of our public resources in the way that they have engaged in so far. Thank you, Mr. Vice President.
Minister of Agriculture, Land and Fisheries.
Mr. Vice President, thank you. And I want to make it very clear from the outset that in my capacity as Minister of Agriculture, Land and Fisheries, I could say that that ministry has distributed no hamper to anybody anywhere in this country. But Mr. Vice President, Senator Mark wants to give the impression that the government's response to COVID-19 has been in the form of 600 hampers. Based on my quick calculations, he's provided figures, repeating some figures provided by MP Rudal Munilal in the other place, which adds up to 600 hampers. A few constituencies are allegedly receiving 50, a few receiving 100. But Mr. Vice President, I would not allow Senator Mark to mislead this country. That has not been the extent of the government's work on COVID-19. Towards the end, I will talk about the work being done through the faith-based organizations, for example, 30 million, simply because in response to a question in the Parliament, in this House, I set out the details of the organizations that were to benefit from the first tranche of that. Mr. Vice President, in response to a question asked 1 week ago by Senator Mark, question number 137 to the Minister of Social Development and Family Services, I provided details on the rental assistance grant, the salary relief grant, and the food support to an estimated 100,000 applicants. So this is not about hampers and pampers, Glenn Ramadas Singh style. The government has provided a comprehensive, world-class, world-leading, much admired response to COVID that extends from the outstanding leadership of the Honorable Prime Minister, the work of the Minister of Health and Member of Parliament for St. Joseph, and soon to return for another 5 years member, the public servants led by the Chief Medical Officer, Dr. Parasram, the regional and international experts supporting, and the citizens of this country that I've emphasized so much about. So it's not just 600 hampers based on an allegation made by MP Munilal, unsubstantiated with lots of threats of substantiation, yet to appear, and parroted, P-A-R-O-T-T-E-D, in this House at this ungodly hour, for which I still have some energy. So, Senator Mark, may I remind you, in relation to outside of all the medical support, last week we had to deal with the supplementary allocation, and we went through. And I, in my contribution, went further into the details. Tobago House of Assembly, 24 million in personal protective equipment, training, THA, Ministry of Health, and all the ministries. Lord have mercy. Mr. Vice President, as at last week, Monday, June 15, 2020, there were 25,000 beneficiaries under the food support program. 25,000, not 600 made up of 50 hamper here and 50 hamper there. 50,000 individuals. We have no way of knowing who is PNM and UNC. These people applied. 50,000 individuals who had their incomes reduced benefited under the food support program. 20,000 households, whether they're UNC, we don't know. We don't have a scanner to figure how you know. So bring the evidence. 20,000 households have become beneficiaries under the food support program. 42,000, you telling me is only UNC people or PNM people? 40,000 current beneficiaries of public assistance and disability assistance grant have had their income support increased. 42,000. 47,000 who have had their salary reduced or cut will receive support under the income support grant. And the Minister of Finance said on the weekend, we've dealt with, I think, either 37 or 40,000 applicants already. 3,000 citizens who have not yet received their senior citizens pension are receiving $1,500 in support. 500 individuals who have not yet received their disability assistance grants are getting $1,000 in food support. 1,400 in the rec. 1,400 have been provided with hampers during the stay-at-home period. 30,000 are receiving food vouchers. Up to 10,000 are receiving or will receive rental assistance. And the criteria is based on a long-established criteria and database established at the Ministry of Social Development and Family Services, at the Ministry of Education via the school feeding program. Why didn't you talk about that? That it is the MPs who are asked to use their local knowledge of their area to identify families of children who had been receiving school feeding and were now cut off from that. And it is the members of Parliament who were asked to put forward the names to receive the support from the Ministry of Social Development to compensate for the absence of the school feeding. It is the members of Parliament, all 41. And that was through the Ministry of Education database. And the government didn't. Are you accusing the churches, the Mahasabha, the Baptist faith of colluding with the PNM? It is the faith-based organizations who have been allocated $30 million. And I gave the details as at May 22nd, 2020, 67 religious organizations were paid $9.675 million. A total of 34 religious groups have already submitted reports indicating, Senator Mark, write down this number and play it tomorrow in the playway. 41,314 hampers. You, MP Munilal, and The Guardian last week add up to 600. Listen. They were distributed to households where the average ratio in the households were 3 female to 1 male-headed household. So principally, the religious groups reported, the 34, that these 41,314 hampers, and this is just 1 month, you know. This is just what, well, go and ask me a question, file a question, I'll give you the list of the 34. Go and ask them, 34, and that is just for 1 month, 41,314. And then through the Ministry of Rural Development and Local Government, the minister is there, an additional 30 million in food support was made available through the regional corporation, the 14 regional corporation. Half the PNM is in majority and half the UNC is in majority. So you're telling me in the UNC corporations, all you're giving the support only to the PNM, all you're so stupid. So, Mr. Vice President, this is a nuisance motion, honestly. This is a nuisance motion. This is based on a statement, unsupported, untested, made by MP Munilal, as he's entitled to make in the other place, in the course.
Time's up.
Thank you very much.
Senator Mark.
Yeah, thank you, Mr. Vice President. Mr. Vice President, the other matter I would like to address this evening is the need for the government to remain committed to the rights enshrined under Section 4K of the Constitution in respect of freedom of the press and to discourage attacks on the Fourth Estate. Mr. Vice President, you would be aware that it was on May the 29th, 2020, that a vicious and unprecedented assault and attack was made on the national media by the outgoing Prime Minister. When, Mr. Vice President, the outgoing Prime Minister accused the media companies of not being independent merely because they dared to question that infamous meeting between the government and the Vice President of Venezuela. And they provided this country with a Nancy story and a fairy tale about COVID-19. And everybody knew after that meeting, 150,000 barrels of gasoline ended up in Venezuela that was supposed to be sent to a place called Aruba. So who was the government fooling about COVID-19 discussion when the real objective was the provision of gasoline to Venezuela? Mr. Vice President, I want to tell you this evening that our democracy is under threat in this country by this Rowley-led regime. Mr. Vice President, anyone who speaks out against this government is accused of being guilty of treason, is accused of being an enemy of the state, is accused of being unpatriotic, is accused of being put to the sword. Mr. Vice President, we need, under our Constitution, to protect a free press. A free press is one of the cornerstones of our democracy. And Mr. Vice President, every citizen has the right to free expression. And speaking the truth does not make you a traitor, does not make you an enemy, does not make you unpatriotic. In fact, we are the true patriots of this nation. Mr. Vice President, I want to tell you this evening that warning signs have appeared on the Trinidad and Tobago radar. The guardrails of our democracy are being eroded and subverted and undermined incrementally, Mr. Vice President. Mr. Vice President, democracy is being eroded almost imperceptibly in our country. And when fear, opportunism, or miscalculation, Mr. Vice President, where a government seeks to establish itself on a platform of untruths and falsehoods and fake news, Mr. Vice President, then we know we are in danger. Would-be authoritarian, Mr. Vice President, seek to subvert our democratic institutions. And Mr. Vice President, we have to defend our institutions, we have to defend our Constitution, and we must not allow the government to use our institutions as political weapons against the citizens of this country. And this is what has been happening, Mr. Vice President. Mr. Vice President, there is a pattern that has emerged under this outgoing PNM regime where they seek, Mr. Vice President, to delegitimize independent voices, whether the attack is on Gabriel Faria, the CEO of the chamber, because he dare express a different view, whether it was against the Law Association, Mr. Vice President, whether it had to do with persons in their private capacity, Mr. Vice President. It is the same taking place all around us, Mr. Vice President. Mr. Vice President, we have noticed that this outgoing government over the last 4.5 years have used their power in this very parliament in order to push through amendments to curb people's freedom of access to information. We have just witnessed the government attempt, and they have passed a law to deal with the interception of communication. Anyone, Mr. Vice President, who is a critic or who decides to criticize the government is branded in negative terms. Mr. Vice President, I am saying this evening on behalf of the incoming administration of the United National Congress that this kind of conduct and behavior is more suitable for certain parts of the world, not for Trinidad and Tobago. But we are seeing signs of the time, and we must defend our country and defend our Constitution. So, Mr. Vice President, I raise this matter today because I recall a famous pastor called Pastor Naimola, who was jailed and placed in a concentration camp by Adolf Hitler during the Second World War. And Mr. Vice President, in closing, I want to tell you, he left a famous poem that I would like to recite for this Honorable Senate this evening. When they first came, that was the name of the poem. He left it for us. He said, when they first came, Mr. Vice President, I did not speak out because I was not a communist. Hitler massacred all the communists. Then I did not speak out because Hitler came for the socialists. I was not a socialist. I did not speak out. Then he came for the trade unionists. I was not a trade unionist. I did not speak out. Then he came for the Catholics. I was not a Catholic. I did not speak out. And Mr. Vice President, then they came for the Jews. I was not a Jew. And I did not speak out. He wiped out 4 million Jews. And then they came for me. And there was no one left to speak. Mr. Vice President, we are seeing an erosion of our freedoms, our liberties, and we are seeing an attack on our institutions, whether it is the media, whether it is the public service, whether it is the police service. Wherever you go, Mr. Vice President, the government of this country is engaging in an all-out assault on democracy, on our freedoms, on our liberties, because they want to transform this country into a full-fledged authoritarian dictatorship. That is the objective of this PNM government. But, Mr. Vice President, I give you the assurance, and I give Trinidad and Tobago the assurance, it is only a matter of time before we go to the polls and we deal with this bunch that are about to leave the corridors of power. They cannot continue to try to erode our rights and our freedoms, Mr. Vice President. And I stand here this evening in defense of the media, in defense of our Constitution, in defense of democracy. I stand in defense of Sections 4 and 5 of our Constitution, which is daily being eroded by legislation brought by this government to undermine our freedom and our liberties and our fundamental rights. So, Mr. Vice President, I serve notice on this government. They can run, they can't hide. They must call elections. Either they call it very shortly or they must call it by the 23rd of December. My view is that they will call it shortly. And when they call it, the people will speak. It will be licks like peas for the PNM. That will be the end of them. Thank you very much, Mr. Vice President.
General. Mr. Vice President, the cemetery of political rhetoric is now completely full. the rantings and ravings of conspiracy theorists are certainly well known to historians around this earth. Indeed, we got a perfect lecture of a perfect sample of exactly what rhetoric looks like. Senator Mark has perfected the art in a way that one can hardly challenge, Mr. Vice President. Rhetoric begins with wild fantasy. Wild fantasy usually involves the kind of content brought by my learned friend. Our Constitution guarantees the right of expression and freedom of thought. But in our Parliament, we enjoy a parliamentary privilege where we are protected from our expression as parliamentarians in these hallowed halls. Mr. Vice President, most regrettably, that privilege does not allow one the benefit and joy of claims in defamation or of having one arrested for libelous intent of a particular type of criminality that is recognized under our laws. In those circumstances, I wonder why Senator Mark finds solace in the Parliament as opposed to the platform. These things could be said in the public domain where one has the right to take house and land in settlement of damages for defamation of character. I reject the scurrilous allegations of wild fantasy born and grown in a cemetery of political rhetoric, Mr. Vice President. There's no truth, there's no merit, there's no substance. Fantasy, fantasy, fantasy. Thank you, Mr. Vice President.
Honourable Senators, the question is that this Senate do now adjourn to Tuesday, June the 23rd, 2020 at 1:30 p.m. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The Senate now stands adjourned to Tuesday, June 23rd, 2020 at 1:30 p.m.